So, and one automatic results in 1956. That might not be national security.
Worry.
Yes,
So,
I
I think we have been able to gather or recapitulate the entire facts. There is no difficulty. As you know, Anil Rai's judgment,
Yes,
My
here
lord.
it says you'll have to place it again
That's right.
and give
My
an
lord.
opportunity.
My lord. Lord, we have already made our submissions. Already
I know it,
writing in
sir,
detail.
but the difficulty is that we'll have to place the matter again.
My
Just
lord.
to, yes.
Can I just take the question by written submission? Because that will be just to explain the written submission that will actually
Yes.
give your lordship of property.
Give me the written submission as well. Yes.
So, Lord, the writ petition is now finally been argued on the basis of promissory stop.
Yes. Yes.
Because there was
My
a.
lord, may I, my lord, I'm sorry, I didn't want to intervene. But in case my lords are going to hear it, my lord, then I would like to, my lord, appear physically.
No, I'm just giving a recap of.
No, it's a recapitulation. This Mehta, it is a recapitulation. What you wanted to say? Yes.
My lord, recapitulation should not be a, my lord, fresh hearing. No, my lord,
Sir,
we
you
have
can
both filed our written submissions.
virtually you can appear. You have also filed your notes of
We
argument.
have both filed our written submissions, so that is good enough
Yes,
for
let him continue.
My lord,
This bench
my
is sitting only for a day.
my lords.
So, Lord, the agreement was of 5/2004, where I was supposed to bring in a certain amount of investment. And the investment also was time linked, that I was to bring the investment before a particular period of time, which I completely abided. And by 2008 and 9, Lord, my smelter also was operational well before Lord, the time limit provided by the state. Now, in terms of the refinery came even earlier, 2007. In terms of this agreement, Lord, I was to be given 150 million tons of bauxite at a price which is very important, a price which is 1.5 times of what is being given to not a captive mine. Captive mine is getting this same bauxite for only paying 100% royalty. I'm paying 150% royalty. And I have said so in my written submission, Lord, that there were two captive mines, one with 200 million ton, one with 300 million ton, where they only paid, Lord, the royalty to the state and without any assurance of investment, except, of course, not to have the industry set up there, that particular industry set up, which is Nalco and Hindalco. So, Lord, I was under this agreement, I was obliged to pay more than what a captive mine was paying by 50%. And I was only to be given 150 million ton, which is far less than what a captive mine is getting. Captive mine is getting 200 million ton and 300 million ton. I mean, the capacity of these captive mines of the bauxite available in these mines. When, Lord, this supply did not happen, obviously, Lord, I was in a very big fix because I was also given a particular mine from which I was supposed to be given, for which there was to be a joint venture agreement. And I did all my part as far as that particular mine is concerned, which is Lanjigarh. I made in that substantial investment for the purposes of getting that mine also allocated and functional and for the environmental clearance, etc. Now, Lord, what happened thereafter? That till 2018, I got no mineral supply at all, although I had started by manufacturing in 2007 itself. And 2008-9, I had started the smelter also. They started with the policy of 2018, where they gave me a mineral at a slightly higher price than what was agreed. So, since I was starving for 11 years, I started that supply. But very soon I realized that they don't want to continue at that rate, and they started not making demands for a much higher rate. Then it is that stage not that I filed this amended this rate petition for the purposes of. So in the policy itself, Lord, there was a mention that there are a lot of people in the state who have set up industries and who have fulfilled all their commitments and are starving for the mineral because of which the policy came in. So that's how the policy also started. So when they ultimately, Lord, started wanting to extract their pound of flesh, is the time when, Lord, I amended the writ petition, and your lordships have then heard the matter after the amendment. The pound of flesh was being Lord, demanded on the basis of a completely erroneous interpretation of Rule 45, Because 45 is not dealing with merchant sale or individual sale of mineral. It is only with regard to auction of mineral block and what is the reserve price which is to be fixed for the purposes of auction. That is, of course, clarified by the central government. We have no difficulty as far as that is concerned. And in fact, they also gave up for Rule 45. In their later policy, they have not relied upon Rule 45. They have also only said that we will go by the auction price, which, of course, for small blocks, they started getting very high rate. And obviously, we could not have paid that rate, considering the promise for which we had set up these industries. Then, Lord, in the 2004 agreement, Lord, there was a requirement of Lord having a joint venture, which is in paragraph 7, where I had to have 75% majority stake and they had to have 26%. But with the coming into force of the 2015 MMDR Amendment Act, a joint venture could not have been created with more than 50%. And accordingly, the agreement of 2004, to the extent of the joint venture, only got nullified. And their promise to continue their supplies under the agreement is established even after the amendment to the MMDR Act by their own Gazette notification of 17/10/2015, where they specifically mention that the Laljigarh mine shall be used exclusively for the purposes of supplying bauxite to us, and that is what the original mine was built to be for. Then, Lord, interestingly, there is a judgment of the Supreme Court also, which came in between with regard to Lord this very mining of bauxite, where Supreme Court also imposed certain additional onerous conditions upon us in terms of financial liability for this mining. So, apart from what we were to pay to them as royalty, I was also to do in terms of Supreme Court a lot of work or investment in that area, which Supreme Court wanted me to do additionally. So, Supreme Court in 2008 very categorically said that if because of this additional investment, if there is a depression of my profit, then I'm entitled to get a reduction in the price of 2004 price also. That is, I quoted that paragraph in this order. If you Lordship will see in paragraph 10, it very clearly Supreme Court says, if in the end of the accounting year of SIIL, CEC find that the annual earnings before tax and interest is depressed by the pricing mechanism mentioned in the joint venture agreement dated 5/10/2004, so then it would be open to the CEC to move this court with the suggested. So they said that you can come for a further reduction in price. Of course, that eventuality never arose because the mineral from Laljigarh could never be extracted. And all my investment in Laljigarh, which is to the tune of 150 crore, for that particular mine is all line based. In fact, state is wanting to use that very investment to start that mining itself in Laljigarh, because now after the amendment, for the aluminium bauxite mining, they don't require a central government permission, which is also not noticed in the Supreme Court judgment in the case of Bhushan Power and Steel, that after the amendment, now it is not one of those minerals where they require central government permission at all. That mining can be done by them on their own. And as far as mining that on their own is concerned, they have said that we'll use this investment that I have done for the purposes of continuing with the environmental clearance, because there is a lot of deposit made towards environmental clearance. And then, Lord, I also rely upon the 43 of the Transfer of Property Act, because if you are supposing at the time of entering into an agreement, if your rights are inchoate, and if later on your rights are further, your rights become completely established as far as a particular property is concerned, only for the purpose of analogy, then today they can't say that they will not give me. Firstly, mineral is to be given from any mine. It is not to be given from any particular mine, because the agreement itself said this mine, that mine, or any other mine having 150 million ton capacity. But today, under the new policy, after 2015 amendment, aluminium bauxite mining is completely within the state control. They don't require any central government permission. So, it's not for them to say that we can't give mineral is completely not justified, and they cannot be permitted to say that we will not give you mineral. And then I also rely upon Motilal Padappat only for the limited extent. Of course, main is of course the mystery estoppel was established in that case. But there is a very interesting question with regard to waiver. And the Motilal Padappat view also, the argument was that they have waived their right by virtue of their conduct, etc. So Supreme Court says that no, waiver has to be firstly pleaded and proved. And if somebody accepts something under duress, that can't be said. Because there also the question was that they had agreed to pay that higher sales tax in the interregnum. So the argument was that now they have waived the rights and they can't get the benefit of a promissory estoppel. So Supreme Court says no, waiver firstly has to be proved, and if somebody has paid under duress, that will not be a waiver at all as far as his right is concerned. And then, Lord, I've given all those judgments, Lord, of promissory estoppel. And Lord, then I say lastly that I have supplied, I have taken bauxite under the various interim orders where, Lord, I have paid far more than what I was supposed to pay under the agreement. So that will have to be adjusted if your Lordship finally agree with me as far as the supply of bauxite is concerned. And Lord, as far as Laljigarh is concerned, they take a plea because that mine is still not operational, because your Lordships are in great jurisdiction, that can also be looked at. They say that now that is not possible because Gram Sabha approval, Gram Sabha has yet to give a clearance. Now they are under a completely fallacious understanding that state cannot anymore work that mine because that earlier permission has been withdrawn. Earlier permission is not necessary after the 2015 amendment, which is noticed in Bhushan Steel. So now that mine is completely within the state control and state can go ahead and do the mining. The Lordship will recall that is the para which I mentioned the steel, where the very section is analyzed, and the section says that after the amendment now, this particular mineral can be extracted by the state without seeking any central government approval. So these are not basically in my written submission I have. And Lord, in the auction, only 2 lakh tons have been sold since 2019-16, whereas we have lifted about 200 lakh to 20 million tons.
The 1% auction is deciding the fate of it.
And wherever, Lord, they have done an auction also, of course, I'm not concerned with that price, because ultimately if I have to get it at my price, which is my agreed price under my memorandum of understanding and agreement, Lord, then it is not relevant. But even what they have got in auction is only not for a very small quantity where somebody has taken a small, it's like the land acquisition matters, Lord, where you acquire a small piece of land, a large piece of land, and somebody says, I have sold a small parcel with this price and accordingly I should get the compensation for the whole. That can't be. That basis is not correct. But really speaking, that is either here or there, because I say that my mineral is to be given to me at the price, Lord, which is determined in the agreement itself. And the price is very clearly there will be royalty plus 50% royalty is what is agreed upon. Whereas the captive mine who have got more mines, more minerals than me, are only playing royalty. So that's the long and short of it. So, Lordship, have any question on any point?
No, we got it. That's
the
actually a rehearing of the case which had already vigorously argued for 5 days. I don't think that any supplementary argument is to be made at the to be mentioned stage. We have filed a very comprehensive written note of submission, which takes care of everything. It is there. And Mr. Mehta, representing the mining corporation, also had argued on the very same point. The question is, by virtue of an interim order, this 1,000 price of alumina, bauxite ore, that is exactly 1/3 or 1/4 of the present market price, which is determined as per the prevailing pursuant to the auction or by the London Stock Exchange that they decided. So therefore, the state's revenue is of paramount consideration, and that too the petitioner has also taken another ledge on in pursuance of an auction. So the property belongs to the state, and the fair price which is expected to be realized from a particular industry or etc., that price the state can't afford to lose. So we have exhaustively dealt with the question of law, the factual background, and also the agreement which was valid till a particular period that has already expired. So there is no question of granting any kind of relief beyond what was done by virtue of an interim order. So therefore, he is enjoying that right due to your Lordship's order passed sometime in 2021 or 22, like that. So
I understand, Mr. Advocate General. What we find is that there were two notes of submission given by you.
But this is the final one.
So,
Final,
Yes.
final one. Initially,
Yeah.
my lord, there were.
where is the final one?
But this is the final one, so, which was in fact filed before this honorable court.
Where is the final one? So that we can actually be find these kind of.
We have already.
If you have already filed
We have given.
There is one, the thick one, there is another, the thin one.
Including the judgment.
We have given a list of dates, written note of submission, as well as a compilation of judgments. All three we have given.
If it is not there, kindly provide another 2 copies to the
Provided.
honorable court and also to the other side.
No, you are providing us a list of dates.
List of dates as well as the written note of submission, where we have record to the judgments, which are given separately in the compilation.
He has
So
given
additionally,
now.
we can keep one more.
This is what
Additionally,
you are now giving,
Yes.
and these are already on record. Please consider that.
Yes.
Give it separately. Oh. This is the two
No, but-
one is with us. And this is the one you are giving now.
You should see this one.
No, this is.
This one.
There is a revised one. I think.
Fine,
my lord,
there are
we can
two.
Yes.
That is what
My
I'm
lord, we
saying.
can file one. Let him.
This is the example.
My lord, we can
We
file
get
one
today.
consolidated one
Yeah,
today.
For the composite, because I find there is a commonality
That's
so
correct.
far
That's
as the one of the argument is concerned.
Yes, but this is the exhaustive
Lord,
one.
we'll file to.
The date.
You
put the
keep
date
it.
today.
You keep it. You file it. By end of the day, my lord, we are filing it with copy to the other
No,
side.
there are two one that comes. That is what is there.
Let there not be any confusion in court. Let me check it also. I had finally vetted one.
Because the
final
difficulty,
one.
Mr. Advocate General, while dictating the judgment, the difficulty is that so many written notes of arguments are coming, and it is very difficult for us that whom you are relying on. We do not remember because sometimes it says don't look at it, look at this one. So we don't know. Sometimes it jumbled up by office.
Let-
So that's why I wanted to have a clarity on that point.
We are filing a consolidate. Mr. Das, you kindly
The composite, let him
By
say that
establish-
this is a composite one, so we can deal with that.
We will file it by end of the day, my lord. You
No,
keep it
he
just
has
as-
given. I have found.
Yeah, put the date, today's date, in the left hand corner.
Now what is
The same thing, the copy.
one copy? Okay.
Your lordship. The lordship's.
No, I find there is already on record previously, but I find another copy was there. So I do not know whether that copy is.
This is the exhaustive.
Yes.
And we have also given a compilation of judgments.
Yes.
Which corresponds to the citations.
This what? Spiral. And this is a list of dates.
This one.
Yes, Mr. Advocate General. Now there is a clarity. Please
Yes,
put it in a different, the tie up in a different way. Tie up theirs in a different way. All the written notes of argument. You have a 3-page of argument.
Yes, I have made a 3-page and I have also annexed the list of.
Because there is another, I think there are again a 2.
In my case, no, not only one.
Yes, please.
Already in that.
Yours is this date.
Please look at it.
No,
These
list of
are,
date is separate. I have not given the list of dates.
Malad in the.
This you have. Right.
This was right, sir. इसमें नाम लिखा हुआ है. This is the right.
no, there also the name is given for the petitioner.
वो final that is the extra copy है.
You just look at it again. Your junior is in confusing state of mind. So let her
This is final.
let us dispel all these confusion.
This is final.
Mr. Prasad, you have
This one is
compiled.
Yes.
Just check
This
it
is
out.
after resolving judgment. I
Which one is?
hearing
Give it.
required for short notice.
So what are the pages?
That's a- it's an- all done.
And then you have given a list of dates as well.
That's
Which we are keeping. We are keeping. And you have also given an unamended copy of the mineral
Yes.
this development act. This
That's
is
right.
unamended. And later on, you have given us, I would say, the spate of judgments which you wanted.
The entire bunch of.
You just keep it in that way.
Only-
Mr. Mehta, it's now your turn. Just give me his.
My lords. Lord, we have filed a list of dates on 12th of May 2026.
Just to find out.
But it is running into Lord's,
But to be
25
very
pages.
frank, at the time of preparation and the dictation,
My lords.
the heap of the paper was such that I cannot see the face of my recording officer.
I can understand. It's a quite bulky record of
Just
details.
not to have this, otherwise it would not be.
So it was like this, so I cannot see his face, whether what he's writing.
But I appreciate that, lords. But my
Yes.
lord, can you take our list of dates? Which is
That is Mr. Mehta. Your counterpart is here. Is it this one? You have, please clarify it.
My lords.
Where is Mr. Prabhat?
Lord, we had earlier, this last one.
Who is appearing with Mr. Mehta?
Why is it dated 12th of May?
He is there. He is there.
Everybody is on a virtual mode. Nobody, at least one counterpart must be here physically.
No, his counterpart here.
He's here.
I think he is
Lord,
not.
someone is there. My
Then what is the utility of
He is
him being
briefing.
physically present?
associate is there.
Mr. Prabhat is briefing. What is your final written note?
Lord, the 12th of May is the list of dates. My lord,
Can you
it's
identify?
pages.
Yes. Yeah, Mr.
My lord got it.
These are the three one which is lying with us.
But the final list of dates is 12th of May running into 21 pages. And the serial number is 101 at the end.
No, your counterpart, let him, because there are many.
My lord,
There are many. Let him.
my lord, we will do that.
Yes, yes, written.
Oh, I know. At the top, this is what our court officer has written. What is this? This is the final one. It is the notes of argument ranges up to the page 6.
The note of arguments is page 6. That is correct.
Correct. And then the list of dates is also there.
But that is 21 pages. It is 12th of May.
Yes.
My
Yes.
lord got it.
Yes. And there is another list. I think the comparison chart of the pleading you have said rejoinder.
My lords.
And then there is the convenience compliance.
My convenience comparison we had filed.
Convenience compilation is there.
But both the documents as well as the judgment we had filed convenience compilation. In pink color.
And then the 20 judgments you are citing.
My lords. I had given the consolidated compilation. It also a judgment not relied upon by both the parties. So my lord convenience. I've got all the lords documents now. The written submission list of dates, compilations of lords documents and judgments. I can file extra copies. My lords.
No, it's not required. It's not required. This is only the 3 arguing counsels.
My lords. If my lord, now kindly take my written note of submissions.
No.
Note of arguments. I'll just quickly recapture it. I will not argue. In response to whatever my learned friend.
Yes.
If my written note of arguments is dated 18th of May.
We don't have the dates with us, Mr. Mehta, to be very, very, very frank. We don't have a dates which is recorded.
The date is at the end of the law. It's on the 6th page.
Yes, I got it. Yes, at the end. Yes.
The 6 pages note.
Yes.
But,
You have taken a first plea of barred by limitation, delay, latches, and waiver and accuses.
My lords. Lord, submission, my lord, is that the first prayer seeking, my lord, the enforcement of promissory estoppel and supply of bauxite as per JV agreements dated 5/10/2004, 18 to 2009. Then with the MOUs, my lord, that is so and so and so, is liable to register on the following grounds. But this is very important. MOU dated 7/6/2003 stood superseded by MOU dated 4/4/2007. And Lord, the MOU dated 4/4/2007 was valid for 2 years only. That is up to 3rd of April 2009. Expired by a flux of time. There is no document record to show that any extension was ever granted by the government of Orissa beyond 3rd April 2009.
Okay.
Accordingly, no enforceable contractual rights survived beyond 3rd April 2009. Then Lord, JV agreement dated 5/10/2004 and 18 to 2009, which provides for raising of vote by JVC, and long-term purchase agreement which became unimplementable by virtue of the amendment of section 17A to B of MMDR Act, which requires that the government company must have the certain share, the predominant share. It is contrary to the JV agreement. Pursuant to amendment of section 17 to B and owing to non-fulfillment of obligation, both JV agreements but validly terminated by OMC by letter dated 30th September 2015, after providing a possibility of hearing to the petitioner and after obtaining approval from the government of Orissa. But this has not been challenged. This is very important. But this termination was never challenged. I don't kindly make a note of it.
Yes.
Termination has attained finality. Being never challenged in the meantime, nearly 11 years have elapsed. A fair reading of the preamble as well as those articles which I have mentioned, it means that all articles are interlinked with each other and cannot be separated. So that just the JV agreements were mine specific, but to say that they could give any other mine is not correct. The JV agreements were mine specific. That is not Lanjigarh and not Karlapat. It is either for Lanjigarh or Karlapat. This is admitted position. No mining lot leads either for Lanjigarh or for Karlapat. As per Article 2.4 JV agreement, no approval for government of India or government of Orissa was ever granted for substitution of Karlapat mine. So it will not repeatedly emphasize by my learned friend that he could give any other mine. But the only two mines were Lanjigarh and Karlapat. We could never get. This moon mining was granted in respect of Lanjigarh and requirement was as per Article 2.2 was composite quantity of 150 million tons taken along with Lanjigarh mine. But the composite quantity Article 2.2 cannot be applied independently to another mine. The absence of mining is in respect of Lanjigarh. That is the point. Right? Lanjigarh is the basic mine. If you do not get Lanjigarh, then nothing can be done. If not, the agreement will become inoperative. Therefore, the agreement of that there has been partial termination of JVAs is completely misconceived. There is no partial termination of JVAs. 2004-2009. JV agreements were terminated in entirety by the letter which I have referred to my lord. It was never challenged. And they cannot be separated. Article 2.2 of the JVA became inoperative. The date of the grant order dated 5/2004. This was Lanjigarh. It will fluctuate by virtue of section 10(2)(8). By letter of 3rd March 15, Vedanta intimated to the director of section before OMC. Would like to terminate JV agreements and so on. So this is very important. These are we are filing, exercising the compilation, exercising its option as per provisions of JV agreement. Accordingly, JV agreements have been validly terminated by letter date so and so, without any assurance to provide any hinder to the petitioner. The pricing mechanism of 2004 JVA. It should be 2004, not 2004. The Lord may kindly correct in para 1.6. By mistake, it is 204, it is 2004. Vedanta having accepted the benefits flowing from the letter dated 30th September 2015 of OMC, it has stopped from claiming the benefits of 2003 and 2007 MOUs, 4 and 9 JV agreements. They are no more in force. It cannot blow hot and cold simultaneously. In the 3 agreements, they are very important. The 3 earlier writ petitions which they filed, the Vedanta file, Vedanta never sought enforcement of MOUs or JV agreements. The plea of promissory estoppel was raised for the first time in December 2025. From 2020, petitions are being filed. 22 were filed, 21 and 1 petition was
Oh, I
filed.
got it. You say that after the certain auctions were
My lords.
successful, they just wanted to
My
alter
lords.
it, and that is according to you is the afterthought one.
My lord. Then
Whatever.
there are 1.8. Both 29, 30 September, whom is letter dated so and so, assured supply of bauxite and the long-term linkage policy of state government. Such assurance of supply of bauxite according to the LGN policy of state was followed by government of India notice dated so and so.
So according to you, subsequent agreement which was entered into,
My lords.
according to you, subsequent agreement was entered into that really forecloses whatever the
lords.
earlier promises were. That is what you
My
wanted to say in 1.2.
My lords. My lords. There is no document on record to show over the last 4 lines. There was no document on record to show that there was any assurance after 29, 30th March, 13th September 2015, as termination of the JVAs and to supply 150 million tons of bauxite to Vedanta at the pricing mechanism. That really clinches the issue. That order of termination is not challenged. The benefits thereafter are obtained. If not after obtaining the benefits, they certainly will take Lord's turnaround. Not say the volte-face and not say that now I'm telling you the action and I'm seeking to enforce promissory estoppel.
Yes, I got you. That you wanted to say. And then
Then kindly return to the next page 3.
that is a doctrine of estoppel, acquiescence, waiver, and the
What is
approbation
submission?
and reprobation.
My lord, before the agreement supersedes.
I think any other word has not been used.
My lords.
Apart from this, any other words are used. Estoppel, as acquiescence, waiver,
My lords.
and approbation and reprobation.
My
Hot
lords.
and cold.
Any other word?
Hot and cold.
No, my lords.
Blowing hot and cold.
Blowing hot and cold, yes. That's
Yes,
my
blowing
lord
hot
is
and
right.
cold.
That also, Lord, my lord is right. Lord,
Yes.
But kindly not permit to page 3, 6 and at the top. The agreements were not supersede in 2004 and 2007 MOUs and 2004 and 9 agreements entirely. Evident from a reading of clause 24 of LTL sale agreement, it provides that any decision arrived at in the past, they are very important. In the past and before commencement of the said LTL sales agreement, can superseded by the said LTL sales agreement. Further, the terms and conditions of the LTL sales agreement shall prevail over all such previous correspondences and decision commitments. This is very important. They're not, so with this agreement, not all the earlier agreement is now sought to be enforced by the promissory estoppel not superseded. Right, this is they said in para 1.9 of written submissions or 1.8 of written submissions. But then 1.8. Then not which I read to my lords. 1.9, my lord, pricing mechanism for JV agreement is money specific and only applicable.
No, I understood. We have gone into the second limb of argument, but that was a doctrine of estoppel, which you have
My lord.
started from paragraph 2 onwards.
My lords.
So you have really said that subsequently the several agreements were entered into,
My
and the
lords.
moment they have entered into an agreement without raising any objections and
My lord.
really have acted thereupon. So the question of legitimate expectation way back in the year 2004 does not arise. This is
The
what
agreement-
your
My lords. My lords. I'm sorry, my lords. I'm saying something. And that agreement specifically states that all earlier arrangement will stand superseded. That's very important. That my lords have noted. To kindly come to page 4, period number 2. Having accepted the benefits flowing from termination letter dated so and so and government will notified so and so. Things of the letter of so and so.
the crux is 2.11, the bold
I know.
one. I
Yes,
think
yes,
the
okay.
crux you wanted to say is this one.
My lord. Janata cannot simultaneously accept the benefits flowing from the termination letter by indirectly challenging the said termination by seeking enforcement of the agreements. My lord, what the crux of the matter? That is the crux of the matter. The pleading, Lord, we have mentioned the paragraph where the pleadings are there. That's for my lord's reference. But then kindly come to 2.11.
That is what I'm saying. The bold letters,
My lords.
what you have highlighted is your actual argument.
My lords, my lords. My lords are right. That my way of not done it for with that purpose only. So it can be highlighted. But page 5, my lords, is page 4, that the highlighted portion, my lords, are seen 2.11. And so before that 2.9, pleadings with regard to waiver and acquisitions have been made in para so and so of the lieutenant or the etc. That will be mentioned. 2.11. Documents of record reveal that on and after 30th September 15, there was no assurance to supply 150 million tons of bauxite by OMC at the pricing mechanism 2004 JVA. And that particles 4 and 9 JV have agreed for substitution of a new contract. Well, I have already said that I will not repeat it. It's an admitted fact that out of the total annual production capacity of 3 million is very important. I had emphasized in the hearing also. Out of the total annual production capacity of 3 million tons of particularly bauxite mines, Vedanta is getting 2.4 million tons. 80% of the bauxite as per annum, as per LTL sales agreement dated 16/5/2003. And rest 20% only is put to national auction for price discovery. Kindly see the blood equities also which is the parking blood, not in favor of my friend. He's already getting 80% of the total production. The 20% is put to auction, nationally auction, in which also he is entitled to participate. Still he has a grievance. Limitation, then about the degree of limitation, that is the please time bar. Pleading for para 3.3 pleading with regard to delay and lashes and limitation have been made in para so and so that we have referred to the paragraph. MOU and JVA are determinable, not specifically enforceable, but that is not the next heading. Then we kindly turn over to page 5. But the constitutionality of Rule 45 that we have made our submissions.
No, there is no argument advanced on that. Unnecessarily.
Perhaps my friend also did not really emphasize the 45 since the point was raised.
He has simply restricted the argument on a legitimate expectation. So that is what is there.
So I will not bother my lord with this. Then result affidavit creating no practice not. I'll just go to summary of submissions on the last page. Kindly permit me to read only that. I'll just quickly read the summary. MOU dated 7/6/2003 superseded by MOU dated 4/4/2007. Itself expired on the 3rd April 2009 by a flux of time. No extension of time was ever granted. No enforceable contractual rights survived beyond 2009. That is section 4 and 4 of the specific daily right we relied upon. JV agreement 2004 and 2009 were validly terminated with effect from 29-30 September in their entirety. Termination was never challenged. Vedanta has accepted and availed the benefits flowing from that letter for nearly 11 years. Present claim in 2025-26, 17 years from expiry 2007 MOU and nearly 11 years from termination of the JV, the expression part by limitation. No explanation for the not delay has been tendered. And doctrine of promissory escrow cannot be invoked against law. Section 17A2B of the MDR Act with respect of promise and possible performance. After unconditional acceptance of all benefits of proceeding contractual agreements, Vedanta wants rewriting of the clause 4 of both LTL sales agreement, which is permissible in law. Pair 8.1 and 8.2. Contradicts pair C and D, CP implementation of pricing mechanism under LTL policy amended in 2024-18. We accepted the LTL policy regime, Vedanta cannot simultaneously demand 100% bauxite of 2004 TVA pricing. 45 1 OMC is legal, valid, and consumer did not bother my own. Vedanta's attempt to revive a dead cause of action was staged by your amendment in December 25. 17 years after expiry of the MOU and termination of the JV that finality is permissible in law and in equity. That is our submission, that petition the order of any merit liable to be dismissed.
Yes.
So that is our aspect of submission.
Thank you.
Only plot 5 minutes to deal with, because there is one plot, this written submission filed by the state which was not filed earlier. We filed for the first time. Only I deal with only.
No, it is just a reproduction
No,
of what the earlier one.
There
There were two different But now they have compiled into one.
So just 5 minutes, I'll not take more than 5 minutes. First, my first point is not that promissory estoppel or legitimate expectation do not require things to be put on paper. Only conduct is good enough for me to claim promissory estoppel.
What is this? This is. Just give it.
Promissory estoppel or legitimate expectation do not require an agreement or something written down to claim either of these two. This can be claimed only by the conduct only. But fortunately for us,
Promissory estoppel and.
promissory estoppel or legitimate expectation
Achha.
do not require, the law is very clear on that. I've already given those judgments. Do not
Yes.
require a written argument, written agreement or a written promise. The conduct itself is good enough for me to establish promissory estoppel. That is number one. Number two, Lord, in this case, there is a written agreement. What my friends are arguing contrary to that. Just have looked, Lord, at my list of date at page 2.
Yes.
Just
Yes.
have a look at the list of date, page 2, Lord. My list of date. The detailed list of date.
Bro, I'm very sorry, bro. They can't even not the re-hearing of the matter.
No.
Joining, nothing good. Because
That's-
the advocate general has given something for the first time. I just want to know that.
Yes.
Let's see page 2.
Yes.
Just see, Lord, this clause 2.2 is quoted there.
Yes.
In the event a mining lease is not granted by the government of Orissa for the Karlapat mine, any other bauxite mine having at least equal quantity of bauxite deposit, subject to having at least a composite quantity of 150 million ton, when taken along with Lanjigarh, shall be
No,
paid
that is what you argued, that it is
Yes,
not
but-
restricted,
but-
it is not request.
Either of these mine can be any other.
It
Now,
can be
the
given.
last submission is not with regard to 17 to A, 17 A to B. Just have a look at that section, Lord.
But it's any other mine taken along with Lanjigarh. That is important.
Yes.
No, that is true. He says that it cannot be restricted. It is something which is open. Let us see.
And now,
Law says any other mine along with Lanjigarh, not minus Lanjigarh. That is my lord.
Yes, that will consider it.
my lord have to deal with that.
That will consider. Don't
Now,
worry.
please see 17A to B, Lord. 17A, because the Advocate General
Yeah.
says that there is a statutory bar and estoppel cannot be against the statute. That is what the argument appears to be. Plus this is the argument of both Mr. Mehta and the Advocate General. Reservation of areas for the purpose of conservation. That is how
17A.
17A to B. Where
Yes.
the government company, I'm sorry. 17A
Yes.
to B.
Yes.
Where the government company or corporation is desirous of carrying out the prospecting operations or mining operation in joint venture with other persons, the joint venture partner shall be selected through competitive process, and such government company or corporation shall hold.
No, that is what is the 70%, which got changed subsequently amended.
I'm not asking for the joint venture to be, if I supposing a prayer had been, that you still have the joint venture with you. I'm not asking that. I'm only asking for mineral. Your promise is to give me mineral. Whether it is to the joint venture or whether it is, because you still are having the mineral, no doubt about it. You are selling the mineral to me, no doubt about it. The mineral is entirely in your control, no doubt about it. So your obligation to give me the mineral is not flowing from 17A to B. 17A to B. 17A to B is only with regard to the joint venture, which could not. And please see not the termination. Just see one more page and I'm done, Lord. Just see in my termination letter, that's serial number 24. In the termination letter, I accept the termination because termination was co-op not having the joint venture. Just see the termination letter at serial number 24. The termination letter also very clearly says
Yes.
supply of bauxite to the refinery would be in accordance with the long-term linkage policy formulated by the government. So it is not saying that I am not entitled to supply. Termination letter also saying that I am entitled to supply. This actually is in court, Lord. It should be in court. This is there in the original letter. The original letter, your lordship will find
That page.
Roger reference is given, 194
Yeah.
of the OMC reply.
Yes.
It is, my lord, one interruption. Is it being reheard?
No, I am only responding.
No,
We
it
have
is.
to
It is.
express an affair.
Mr. Advocate General, no difficulty. This matter is being reheard. There is no difficulty. I am conscious of that judgment of the Supreme Court, the Anil Rai's judgment. That is what the reason is for placing these matters. Nothing more than that.
It is important
Yeah,
not
then
until
we
the
have
lawsuit
to
forget
address
what is
on this.
until.
Oh, just to be.
But that is why I said that it should be at least a basic point. And
That is what says that if it is crosses the 3 months, then you should place it again before
Absolutely.
the page, so that opportunity should be given to the counsels to re-argue the matter. There is no difficulty.
So the learned advocate general, rest of the argument is founded if I fail on promissory estoppel. If I succeed on promissory estoppel, then the other argument of auction tax, etc.
Where is the promise held out?
Yes, very difficult.
That's-
You got 1,000 rupees for material.
Yes. I am also conscious of RAMAN's judgment also of the Supreme Court.
My lord.
Contemporaneous period of time. There is another
When there
judgment.
is no, Milord, when there is no promise, where is the question of estoppel? Promise is
Yes, Mr. Advocate General, what you were saying?
there is no promise as such held out for providing at the rate of 1,000 rupees per
No,
material.
you were talking about that state, the exchequer or something. You were talking about that.
Milord, it's a burden. Milord, the fair supply is not the issue, but supply at the fair price is the issue. He says that I'll be availing at 1,000 rupees for MT.
No, I am obliged only to pay 400 rupees, not more than 400. Which is the
Anyhow,
deeply obliged. Deeply obliged.
yes,
Then
the matter was
say charity
was listed today.
The state can't give the largesse in this manner to any
you have
private
the
party.
cake and eat it too. Both, Milord, he wants to have the cake and eat it too. Both things can't go together. He wants to have an industry and make it for profit and ask the state to compensate for that.
They should ponder upon, because I think they are having a lot of problems. They can't eat cake so easily. Huh?
They want.
In fact, I did want to
Some
bring this up.
industries
In between,
No, on a lighter side, Mr. Advocate General, you can't eat a cake.
No,
On a
we are,
lighter
Milord,
note.
distributing. We can distribute, Milord. The state is not supposed to. We are giving freebies in certain sectors, but
No,
not
I am not talking in that sense.
Planned in a separate
On a lighter side, nowadays, eating so much of sugar is a problem now.
That is
even today,
Milord,
even
No,
They
today,
have
there is having a lot of difficulty in mining, carrying out mining. It's not as if Lord mining is
Yeah.
easy. We
No,
also-
I understand. It is
even
something
today,
now hearing is concluded. Yes.
even today, Gujarat, Maharashtra is giving bauxite at 400 rupees to their induced customers there.
Lord, they can afford to give, let them give, Lord. We can't, Lord.
The
We have
state can afford to do that. Milord,
councils
we
were invited
go on
to
to
address.
My Lord.
So
My Lord, perhaps can maybe need some more time.
No. It's our duty.
My Lord, sir.
very deeply obliged. Very deeply obliged.
My Lord.
This compilation of judgments which state has given. The second item is the Nazir Ahmad judgments which we have referred. I have given the correct citation, but the judgment enclosed is the incorrect one.
So replace it.
Just that
Just
Nazir
replace
Ahmad
it.
judgment I am giving this
You just replace it.
You make it correct.
because it is spiral.
You make it correct.
Right.
That's a danger.
Give it to him, he will staple it.
What
Whatever.
else?
Lord, your Lordship's last order said interim order till judgment. I don't think that is to be reiterated.
That is already there.
It should be. It should be.
My Lord, please.
Yes.
Item number 2.
replaced.
No, we know it, sir. You need not have to remind us to embarrass us. We know it. We just wanted just to recapitulate and because what we know is that there were several orders which were passed. The land was acquired. Then there was a Supreme Court judgment. Several judgments came in the meantime. We say alternative land is to be given. He was not given that alternative land because he says the value of his land and the value which you are offering is not correct.
Yes.
Then he says that at least the value has to be ascertained and be given to him. You say, no, I want to return it. He says now it is too late in a day to return. That is what is the. So several orders have to be assimilated. Several orders have to be. Can you give me that synopsis?
So we need a extensive note.
Please give a synopsis, sequel wise, that what orders were passed and give that compilation.
Yes.
Yeah, when can you give?
I
prepared
Have you compiled the orders as well?
yes.
Let's give him a copy also. So that is this page number is given of this compilation.
Yes, sir. Another development is there, my lord. Of course, it is as per this long hearing. Very recently on April 2nd, 2026, the government has made one benchmark evaluation of the same land, which is 49 crores 43 lakhs 40,000 rupees. The same.
Per?
Yes, my lord. I am giving this
No, per what? Total value.
per acre.
That is what I am asking.
Nowadays.
Now it has been.
So we'll have to go by the order of the court. What should be the date?
14 crores has been determined.
Yes.
I am saying that it is not excessive.
That asks for
Value, sir.
I think this is a complete compilation.
Yes. That is separate.
Well, we'll go by because it is all the effect of the order that would come, nothing more than that.
Saying that it is an indicator of the market value.
Yes, the matter was heard. Put it for judgment on what judgment? On what proposition?
That during execution, the court cannot go behind the.
So this is anyhow you give it. I know. Anyhow you give it those judge.
I don't have 60
Heard for judgment.
Item number 3.
That matter that's the order first, the direction which should fight on the water student is going to be complied with.
What compliance? Say that you have complied with in what manner? What was the direction pass?
Yes.
On page 81 and 82. Annotated 13,525. Just
Page 81, paragraph 14.1.
no, wait. Paragraph 13 and 14 and 14.1. Yes. This order has been confirmed by the Honorable Apex Court also. On 16/1/2027. Thereafter, till date, they have not complied with the order.
I have obtained instructions that the file is now in the finance department.
No, there are two directions. One is the jailer, just stating the same position. Treating the letter of 1990 to not have been issued. If the continuity has to be ensured. And then what the consequential benefit, several benefit has to be done. Where is the dismissal of the
16/1/2020. 16/1/2020.
Now we are in 25th of August. What we were doing?
But it's only 10 days time I'm trying for.
Yes.
Only 10 days time.
What in this time, how much time you require? What word has to be put out? What they think? If this SLP is dismissed on 16th of January, where do we stand now?
Right.
Nearly 7 months has elapsed, and you are saying that give me some time. There is
Per day cost.
That's only 10.
Per day cost.
No, that's only 10 days.
Per day
Yeah.
cost. Per day cost.
let the government advocate appear and justify the action of the order. The order was that he should be reinstated forthwith. This order was challenged by the state of Orissa to the Supreme Court. Supreme Court dismissed SLP on 16th of January. Now we are on 25th of August.
And there is no extension of time.
I think it is a fit case for direct issuance of the rule without asking for any explanation and giving an opportunity to defend.
Views of finance department has been called for and they are also like.
Oh, no. They will sit over it, and that's a right which has fructified, and he's not been getting from 2019 consider.
After dismissal of your.
Let it come next week. I'll tell you.
After dismissal of this special leave, will you not show an alacrity? 7 months have expired.
Would you say that finance
I think it's under process, my lord.
We are directing all these persons to remain, we are directly issuing the.
Let it come next week, my lord.
Definitely not. Now, we find that, yes, the EGA is in a very difficult point. That's why we pointed it out to you. You being the senior most, one of the senior most.
Yes, ma'am.
You should bear the responsibility of the action of the LS contempt.
I'll talk to management today.
Got
Let
it,
it come
got
next
it.
week, my lord.
In every case, the same submissions are made on your side. Not
What is the
only on-
explanation?
of-
Therefore, now we are very critical on.
We
We could have appreciated that after the dismissal, immediate
Revoke judgment of this court. Pending before this court. Note of it.
During the complaint.
Mahinder.
What is that? STC that we.
From 4 plus CC 560.
Yes, right.
Division bonds.
STC is already there.
The objective.
Item number 4.
Actually, SLP has been deferred and the judgment has been stayed.
It's the current adjournment. And as Vijay is done, his senior technology surgeons did.
Another aspect is something. The prayer of the.
Item number 6.
My lord, appearing in item 6, my lord.
My lord,
Will draw Lord's attention, my lord, on page 101, where the direction was passed in December 2025. And then subsequent directions also, my lord. This is really a pathetic case, my lord, where the government has, no, my lord, intention to honor my lord's order.
my lord, we have filed an affidavit on 22/7/26, praying to give some time because the material and the process measurement has been done and committee examined. By 22nd September, the process will be over. That's why the affidavit was sought for 2 months time. Let it come.
What is the present scenario?
My lord, this is the third application filed before
Yes.
your lordship.
What?
This is the third application filed before your lordship. My lord,
My
they're
lord,
seeking
it is
time again and
was
again.
done so far the Boragar canal is concerned. In the
But-
April, when we took up the issue for the measurement and all that, it was necessary to discharge water through for sake of irrigation, my lord.
Concerned,
And
what is more?
material-
I am simply concerned that if there was a direction, what is the direction for your compliance?
My lord would see the direction on page 101, my lord, operative parties 5 and 6. Despite my lord's direction that superintending
Page
engineer
104 is the.
101 is the order, my lord, original order passed by my lords.
Oh, where is the direction?
Direction, my lord, 104. Para 7 and 8, my lord. And my lords have taken note of the inspection conducted by superintending engineer. Therefore, direct direction was given to make the payment. And it is my money, my lord.
Say competent authority to consider the approval of the amount as quantified by such and such, such and such. and the appropriate authority shall disperse the due to the prisoner within second interpretation.
Then my lord
How
would.
can it be a third contempt?
Yes, ma'am.
Why third contempt? Or a third writ petition?
Then they filed an application in February seeking 2 months' time. My lord granted them 1 month time to file it to pay it by 15th of April, not complied with.
Then
Again they filed an application in April. They wanted 4 months' time. That also expired on 13th of August, not paid.
My lord, the
Now
procedure
they
submitted
want
for
to
approval will
re-examine
take some
my lord's
time. That's
order.
why I was sought for 2 months time. Since 22nd of September time I will give it, will comply.
This delay.
the rule framed by this court. No. Framed by this court regarding contempt. Give us. I think there is a provision. What is one for this? There is a contempt rules. Which chapter? Rules related. You can't impede something which is there.
Lordship may kindly look to para 5 of my affidavit filed on 22nd July.
Huh?
We have stated that to comply with the direction issued by the order dated so certain critical measurements particularly led to maximum depth of so and so of a excavated procedure and borrow
This is
feeling dated
this contempt application arises from
Map is given. Case Lord, your lordship on 24th August 2024, portal was blocked. Your lordship on 22nd December 2025, the very after judgment, my lord, judgment was that is completely illegal and recommend direct to unblock the portal within 10 days. Your lordship paragraph page 77 of Annex 1. Almost 8 years, 8 months has been passed. Not a single Lord, it has in spite of recommendation of the authority after knowledge of the order, Lord. But some is a C-class contractor, Lord. Your lordship kindly see the page 77.
Yes.
And relax this judgment, very order was for this
No,
leading
communication was done. Still
no portal has been. Your lordship annexure 2 also recommendation was made. Annexure 3, your lordship. The hour of the court order. Chief engineer recommended to the chief engineer procurement authority to unblock of portal reason, that is January 2026.
Since February, we have already written the letter to unblock the year and take decision.
Have you made them a party?
Yes, Miller.
In two
This
of the cases, one
procurement?
of the cases was done, my lord, in case of Sanjay Agarwal, same order part. And in this case, it is done. In
Serial number 3
February,
is
we have
the
written to them to unblock the court.
Yes.
opposite party number, Miller, contemner 3, your lordship. Is the Miller.
They may be noticed, my lord, individual.
Individual notice has been given
No, that is not in the first time
First
case.
time it
It
has come. I man.
is gone to
by a judgment and order dated 22/12/2015. You have said from 2 to 5 in a official capacity. Where is the name?
Page 1.
Where? I do not
Page
find.
1 of the contract.
Where? Oh, I have been looking. Oh, I am looking at the WC. Sorry, is my bad.
My senior also requested for unblock. They are not such a adamant.
As a party, it is served the copy of the contempt application upon the opposite party number 3 by speed post.
On behalf of MK Ponda, kindly taken next to me. On behalf of MK Ponda, kindly taken next to me.
I taken
Next to me.
two weeks.
Item number 9.
Your also allowed and tell 35 back. Paragraph 8. On setting inside the order of the divisional authority, the order of the appellate authority by which the direction was made to refer to.
Yes, what has happened?
My
Then?
lord, we have filed an affidavit, that is at flag A. My lords, I would request my lords to kindly have a glance at paragraph 5, 6 and 7. But the petition is not cooperating. We have issued 3 notices to him, my lord, after proceeding has.
Where is the flag A?
They are
Flag
issuing notice.
XOA is there, huh?
The flag A.
Sir, you have given an address. It has returned that you are not residing there at.
After that, my lord, because we have found out its present address. Again, notice was sent. He received that notice, the third notice, but he did not appear on the date.
No, what for he will appear, my lord? This is the question. Because your lawsuit's direction.
Sir, will you not go that for? What for you have called for? What for you have invited me to appear?
Which
You will
evidence?
go and say that there is nothing to be gone into.
My
You
lord,
could have gone there.
no, they have written notice that you please come with all papers. Papers are with them. Papers are in the court.
Sir, will you-
But again, how?
I understand, but the direction was
It is going to harass matter because one evidence they have noticed. And on the capacity of SDGen, on evidence.
no. What was the direction
My lord,
of the appellate authority?
whether the authority direction was this matter is absolutely irreferable possible. This is a certified copy.
Correct. So section 8A, the proceeding,
Yes.
and the conscious decision is to be taken by a subdivisional officer.
Under, yes.
So if they have to take a conscious decision, if they call you for a hearing, where is the difficulty?
There is no difficulty, man.
Then why you are not going?
Because they are calling with all papers.
Already, they will not. What is the order? What is the order of the appellate authority to refer? And before reference, will they not do it?
They have already referred. The sub-collector is come for hearing. So
Yes.
This is the certified copy of the.
Then this is there is no violation of the law.
It was possible to take necessary action for referring the matter.
It's a question of referable proceedings. Therefore, he is directed to take a necessary action as under the OPLE Act, giving a due opportunities to the appellate. So he will not go there. So the appellate authority has said that he will take the necessary decision after giving a due opportunity to the appellate. Will you not go there?
That they are going.
No, sir, we are dropping the contempt. There should be some limit in this regard, sir. Sorry, we can't.
Now,
If you want to play tricks, then you play tricks.
no, my lord, I will go, I will send the petitioner to.
Tell him to go.
Again?
Tell him to go.
Yes.
What is the next date fixed?
Next week, madam.
Your officer will be available.
Yes. By a judgment dated 17th October 2025, the order of
item number 10.
Essentially, there's a new page 19, and then I'll take the paragraph number 5.
Yes, what happened?
My lords, in this case, my lord, I have received instructions, but my lord, they are not up to date, my lords, but they reveal some steps have been taken.
Nothing.
My lord,
You have to see that
Yes, my lord.
the lighting poles are installed, the drainage system should be put in use.
Process has begun is what
Yes.
is written, my lord, but this instruction is of last month, so my lord will call the matter next month.
No,
I'll obtain up to date instruction.
this is not a writ petition.
My lord,
Service upon the LS contemner, let them come. Not service. Requisites you put in, returnable after 2 weeks.
11.
Instruction. Has it?
Yes, sir. Will also 2 days time for IA. By IA.
What IA?
For the withdrawal of the content. Withdrawal of the content, madam.
Why? Why you want to withdraw?
The lordship, as per the order, they have already given the amount. So,
So there is nothing. So we record your submission.
lordship the matter file for running bill also escalation for the petitioner. But as per
No, there was there that they fairly submits that they will release that particular deducted amount of rupees 24 lakhs and odd.
24 lakhs.
And odd, I have said, maybe a small fraction.
Escalation bill also not paid.
But that was not a direction here.
Yeah,
That is what?
no. Also,
You are in contempt, madam.
yes, you not.
You should realize that what is the direction? The direction is paragraph 3. They say lastly submits on instruction that a sum of rupees 24 lakhs was deducted shall be paid to the petitioner as there is no justification in withholding the said amount. In view of the stand, we say that you release the said amount, means 24 lakhs and odd. Have they released this amount of 24 lakhs and odd? I'm asking you this question.
As per this, your lordship, we have to pay the amount within two weeks. But after 1 month also, they haven't paid that. Then also we'll file for complaint. And when we got the letter from here, then they paid the 24 lakhs amount.
So now they have already paid.
Yeah.
So what remained?
We will withdraw that complaint.
So what withdraw? We are dropping it. Lago. The
Continue with the content. He only wants to find out.
We have dropped the content. That's all, nothing more than IA list. It is submitted that interlocutory application is filed, which is appearing in the list.
Recalling the order.
List the application on the next. Be ready.
Item number 12.
Non-compliance of other vendors, 4910 to the 2025.
Page.
Your lawsuit, see para 4. Para 4 is
Yes.
judgment minor, 4910.
Just. Contempt is not maintainable. We have not fixed the timeline. We have simply says as expeditiously as possible.
4910, 2025. Till that.
Have you taken the steps? This is a great risk I find that you peoples are taking without a service or a notice of the contempt you are appearing.
At the time of admission.
Now the government advocate has to ponder upon the issues.
It is that your lordship disposed with this very type by instruction of the government council. Yes, your lordship gets.
No, you are appearing, we record your appearance. Oh,
Yes, ma'am.
where is the contemptuous?
Continue your lordship. As per their instruction, your lordship before this is established.
Sir, there is already a instruction that they are taking a step against the encroachment. And we say that they have said that we have already taken a steps against them. In view of them, we say that authorities should complete the process as expeditiously as possible in accordance with law.
More than 10 months have already passed. Nothing particular has been made. Only there, your lordship, only demarcation has been made, but no other proceedings have been evicted. That is my sole question. Your lordship, then.
What are you doing? Why you are not completing?
It's as per the
Affidavit. The LS contemners the LS contemner appears without notice. And therefore the notice of the contempt is waived. It is
the object of the contender had filed in compliance affidavit. And he has filed a reply to that, my lord. I'm filing for the court today, and I'm also serving a copy upon the.
according to you, it is not a compliance.
It is not a compliance, ma'am. If I may apprise my lords. Direction
Anyhow,
of.
despite I got a 2nd July endorsement.
My lord, I
Find out what the affidavit. I have found this. Okay.
This affidavit is by the petitioner.
What is the?
No complaints affidavit is available.
My lord, I think it is not in the record. I have the copy which they have filed. If my lord will perish it was filed on
Bipin Bihari Swami is your client.
my
Just give me.
petitioner. The contender has filed an affidavit. He has served a copy on me on 24th July, my lord, which has
But
been
they have not filed it.
No, Malat, it is e-filed. Malat, my record also shows he filed on 21st July 2026. Malat,
Who has affirmed the affidavit?
it is filed by
One Ajay Kumar Das,
Yes.
sub-divisional police officer,
Direction-
SDPO. And who is the alleged contender?
The alleged is Ankit Kumar Verma, the Superintendent of Police, Jagatsinghpur, Malat. If my lord, if I may apprise my lord of some few facts that have been
What was the direction?
page 31 of my brief, my lord. If I may read, my lord. Direction was given by the court to the SP to render all assistance.
Superintendent.
Superintendent of Police to render all assistance and provide all security so that there is no commotion created by the quarters while making construction.
These are why I always use the word squatters, not quarters.
Understood. That has
I find every time when I am correcting it, this quarters word are coming instead of squatters. Okay, what I have said? No, just again write it. By a judgment and order dated 25th March 2026, the direction was passed upon the Superintendent of Police, Jagat not going of 2015 or a 14 or a 16 or a 21, 22. We don't. Sorry,
Suggesting my lord,
nothing.
advocate commission.
We will not. This is, have you not seen? This is not a normal proceeding. It is a contempt proceeding.
As my lord pleases, I bow.
Then,
I bow. I bow.
Item number 14.
is
Not first. Not fully.
not press. Give a whatever.
Interim order, final order has come in between. The contempt was against the interim order. Now the national has been adjudicated in the final order. It is not this.
Next.
Item number 15.
This contempt has filed against the regime that they have violated or objected 7/5/2025 passed in WPC number 8376 floods are available at page 21. Relevant is at page 22. Paragraph 5.
There is no direction pass. Simply on the it is not a real contempt because there was no direction pass. They said that they have taken a step from the basis thereof it was disposed of.
No, specific direction was there.
Where is that, sir? Paragraph 5, 6.
Your also may kindly turn to Annexure 1, page 11. That matter was originated, the issue cropped up in the WPC number 20917 of 2023. And your also may kindly turn to page 14. Specific direction was there. Paragraph 6. On the face of allegations, we direct the collector
With regard to another writ petition.
same writ petition arising out of this writ petition also.
How can one writ petition arise out of
I have an answer. I have an answer.
Yes.
You wanted that this direction has to be complied with? You wanted this direction to be complied with at page 14?
Page 14, this order has been complied with, and the collector has inquired into the matter and submitted the report before this honorable court, indicating that violation is there. They have enclosed the land.
So,
Then this honorable court directed that you evict the encroachers within a stipulated period.
correct.
Then they came, collector came and filed affidavit that we have already taken the steps, initiated the proceeding against them, and case is fixed to 4/5/2025. That on that day this issue will be decided. Basing upon his submission, this honorable court has closed the proceeding, indicating that since they are taking the steps, no contempt need not.
So all these orders merged with the final order of 7/5 and there is no direction. It is simpliciter recording certain facts and the court has said that no purpose would be subserved to keep it pending. So that is what. So there is no violation in that sense where there is a direction to do a particular thing or not to do a particular thing. In that event, it will be a contempt, but it is a technical contempt.
See the of that.
Yes, please read carefully.
During course of hearing,
Correct?
before that, you also kindly see paragraph 4.
No, I have seen.
Paragraph 4.
Correct. I have seen, I have quoted the order of 5/8/2024. That's, I know.
During course of hearing,
Correct.
Mrs. Such and such, learned additional standing counsel appearing for the state showed us the instruction received from the Tahsildar, Nistinta Koili, wherein it has been clearly stated that effective steps have been taken granting opportunity to the encroachers to vacate the Gochar land encroachment case number such and such, such and such. Both the aforesaid encroachment cases have been posted to 4/6/2025 for final eviction of the encroachment land. This is the undertaken they have given, therefore your lordship.
Oh, it is not an undertaking, sir. There is a distinction between an undertaking and a submissions to be made. You should know, undertaking must be in the form of an affidavit and that amounts to a perjury. And that is also taken very seriously, that once you have given an affidavit to the court, sworn an affidavit, then why you will not comply the order? And on that basis, paragraph 6, we said nothing is going to happen. We are not passing any direction in the PIL. Anyhow.
Your lordship has already passed the order.
So there was already a direction. I do not know. Order. I am against that concept of first contempt, second contempt, and third contempt. I do not know from where this procedure originate and how it is being taken up. I do not know under the law. My incompetence, my ignorance of law. I do not know.
Earlier repeats, your lordship may guide, because I am the remediless now.
So again, yesterday I said that I will not react.
Remediless now. Because your lordship, earlier repetition already specified.
Contempt is not the remedy. Contempt is something else.
Yes.
But earlier repetition, contempt application, your lordship.
The writ petition was disposed of on 7.
In the order already cited the.
What is the
eviction and all that?
Where is the direction? Let me understand the direction, Mr. Government Advocate. Have a patience. Let us see.
Order under Annexure 1, page 53 is the operative.
50. Just we wanted to see the operative portion of yours.
Page 53 of the content. So the petitioner is ventilating since 1990. This is the PI lordship disposed of. Because they have the enclosures have constructed
Yes.
illegal structures over the government land. They have been ventilating since long. So there was a straight direction given to carry out the eviction, my lords. But what the prosecutor has done, my lords, he again initiated the encroachment proceeding. Then again, my lords, the encroachers got the scope to appeal against the order. There is appeal also.
He will get an opportunity. You can't. They can't tinker with the law.
That against that division felt, division also dismissed.
Maybe now they will take.
I have already carried out eviction and process. I have given the instruction issued to Lordship.
Lordship granted a time bound 3 months time, my lord.
3 months time. On 22/6, my lord, second.
How many have been removed?
None. My lord, there were
eight encroachers have been
we
removed.
already demolished them. Then there
Eight
was an attack
encroachers
on
have been
the-
evicted.
Hold on.
Yes, brother. Now it is fixed on 28th and 29th. File affidavit, file affidavit. The government advocate appears.
Item 17, your lordship, I may be permitted to withdraw.
Withdraw.
Item 17, your lordship, may be permitted to withdraw.
We have permitted you, sir.
Oh, bless.
Carefully.
Indulgence to
Start
mention
from it,
item
yeah?
35.
I beg your pardon, Your Lordship, my learned senior is mentioning this.
Can I
What?
claim indulgence to mention
Item number 18.
Item
35 ballots?
Item 35.
So
35.
what will going?
Item 18.
If your lordships can take it
Will be
towards the end
reaching.
of the day, because my learned
Let us
friend
see.
have not got a stay in
Yes,
Supreme
18.
Court.
But item 18 extension, similar order is that the annex 9 page 126.
What?
Extension.
Extension of
Answer.
extension of period.
Similar order you have enclosed.
Yes, ma'am.
So rule
Identical
rule
case.
64. Rule 64.
Yes, ma'am.
64, but he is alleging that for last 4.5 years he could not operate. Regarding that, I will have to take instruction from the operator whether there is
It's up to you,
order
section
for a
64.
limited period.
Section 64, you'll have to take a recourse to it. You are independent to take a decision whether to extend or not to extend. He claims because of the NJT, we will not record anything. He has claimed the prayer C at page 14. Come. He claims, come to page 14.
Yes.
Have you seen that?
Yes, ma'am.
So we are passing the same order. Yes. Huh? NJT.
ଗୋଟେ ଏମିତି ଥିବ କୋଭିଡ ନାହିଁ ଗୋଟେ କୋଭିଡ ର ଗୋଟେ ଏମିତି ଥିବ
Yes.
ଇନକ୍ଲୋଜ କରିଛନ୍ତି ଆନେକ୍ସନ 9 ହେଲା ଆନେକ୍ସନ 9 ସିମିଲାର କହୁଛନ୍ତି ଦେଖିବେ
Yes, 19.
Item 19.
Okay. No, it has come. It has come. Oh. Very erratic. Huh?
Challenging the order on the Annexure 1 and 2, where the demand towards royalty has been raised for a period during which the query is admittedly removed.
additional charges
Royalty and additional.
Royalty.
Additional charges
If you would kindly see the order under Annexure 2, page 17. They are raising this demand.
This is only the royalty which comes. Otherwise, the dead rent and everything you have to pay.
Royalty and additional royalty will.
Here, my lord, issue is different, madam.
Let me place this.
If they have not removed the materials, is the case of removal?
But for a particular period, the query was kept suspended because of seizure of blast materials
Okay.
from the query. for a particular period, it was kept suspended. Then after explanation was offered by the petitioner, that was considered and the suspension order was revoked. Subsequently, the demand notice has been issued, which includes this period. That is what my learned friend alleges. But if your lordship may look at the order that is at annexure 2, this order prima facie it appears to have been passed without considering his so-called reply, because his so-called reply has not been extensively dealt with this order, because this order appears to be a cryptic order that I can fairly submit myself.
No, so then this order should go, and as well as the demand as a whole will go.
Demand made prior to that.
But the question is, again, I'm saying that when you impose a royalty, then there is already a provision relating to the incident of royalty. When the royalty becomes payable,
yes,
the royalty becomes payable in two instances. One, removal from the site,
yes,
or consumption in the site.
So during this suspension period,
so now this is the period.
No removal,
then he is not entitled to a royalty.
Regarding that, because he has replied to the SOCOS and the SOCOS has not been dealt
Sir,
with.
if there is a patent illegality on the face of it, so far as a one component is concerned,
But
then
annexure 1,
then do one thing. We are suspending, and let them decide. They cannot insist for both.
But annexure, my respectable submission.
Third paragraph and last paragraph. Third paragraph suspension was reflected.
Yes.
And last paragraph, last but one paragraph, he says that the reply furnished is not satisfactory.
Not satisfactory.
You want now the authority shall reconsider and give reasons.
So if
He will redo and again demand notice, revised demand notice under Annexure 1.
Here what has happened, the demand notice was issued on 9/6. If your lordship may kindly see Annexure 1. But the hearing of his so-called reply was conducted on 14/7. So what I am saying is this order under Annexure 2. Yes.
Demand preceded the.
Yes. So Annexure 2 if set aside and sent back to the authorities to consider his so-called notice, so that a decision can be taken whether they will stick to this demand or they may also revise this demand.
I appreciate, sir. What do you think we do not appreciate?
No, you are not. I can.
He has challenged both the demand notices as well as the show cause order. Now, suppose the so called order goes and the demand remains, then at least you had an opportunity, or you are within your competence to raise and take steps against the demand.
But no, till consideration of my lord, suppose my lord directs that if so-cause will be considered within a limited period. Within that limited period, let the demand be kept suspended till a decision is taken by the authority. That is what.
Then we'll record, because our view is different. Both of us have taken a different view. That the interim order cannot have a lifespan beyond the final order. So
this is something which
that is what that is why we wanted to say. And this show cause is only for the payment. Why not a proceeding be initiated against you for recovery of that amount?
But if your lordship will look at Annexure 2, the second paragraph, that demand notice has been taken note of. Thereafter, in the third paragraph, where
that he says I am not able to, or I am not obliged to pay.
In the third paragraph, he says that I am not obliged to pay. Now, that aspect has not been properly dealt with in the last preceding paragraph. So, let the authority take a decision.
On the basis of a concession that it will remain suspended. Has to go.
Yes.
And record that till the time final adjudication is made, suspended. No, it has to be. It has to be. Otherwise, it cannot.
This applying the similar order in that like you also this.
Similar orders there.
Already decided. In all these three cases, for some reason or the other, the operation of the lease in question was remained suspended.
With regard to this additional.
Yeah.
Yes. Yes.
Item number 20.
These are our orders. All. Yes. Item 20.
But I'm very frank, I don't second. It will be like next thing.
But oh, they are challenged. They are the writ petitioners.
Yes.
You are the respondent, are successful before the revisional authority in having that demand quashed.
Lord, I am appealing on behalf of Mahanadi Police. There were 73 revision applications of different periods. Now, if your lordship, I can just pass on this to your lordship. This will be convenient to your lordships. If your lordship will just have this.
No, he's asking for an adjournment.
Lord, next week I have a problem because next week I will have a problem.
No, that's true.
Anyway, convenient to my knowledge, 3 years.
Lord,
What is a convenient date?
Lord, 73 RAs. If your lordship will look at
Mr. Counsel, we are asking for a convenient day. At least you are benefited with the order. You are not going to suffer. So they are the writ
I just wanted to
petitioners.
show the selective approach.
We will definitely see that the revisional authority's order is.
My lord, only one order is challenged. One order. 73 orders have been passed between 2020, between 2023.
Take a plea. Would you like to file your opposition?
My lord, I've given that. I don't think your lordship will need much more than that. Because other orders have become final, attained finality.
Against you.
Yes.
73 orders
In my
against
favor,
you.
In my favor.
No,
73 orders.
Means you are a party. Against you, you filed a 73 revisional application.
I filed 73 revisional
Correct.
applications.
And all the revisional applications were allowed by a common judgment or by separate judgment.
Different orders. And those orders are between 2022 to 25. And what they have challenged is an order of 31/10/2023. And that has been filed in the year 14/5/2025. Now, rest of the orders, all orders are identical common orders. And in respect of the same cause of action.
Mr. Mitra.
Yes, sir.
You could not take the cue from London Additional Government Advocate. He doesn't want to take the risk of doing this. He would engage. That's why he is seeking for some. We could understand that.
Tell me the date.
Yes, my lord. My lord, could your lordships have it on the 9th, if it's convenient? And it's
9th is a Wednesday, actually. I think Tuesday and Thursday, my brother has a single bench.
The lordship have it on the
8th we can.
8th of September.
8th of September. Now consider this point. If on an identical issue a decision has been taken and you are challenging only one, the rest is there. So,
Lord, my learned friend also has to consider the fact that I'm not a lessee. The land has been acquired under the Coal Bearings Acquisition and Development Act. I do not pay royalty. I pay an amount in
Are
lieu of
you,
royalty.
you are a government of
India,
undertaking.
government of India,
They are
the state.
one organ against another organ.
No mediation.
Because under the provisions under which this charge has been made, it is relates only to the lessees under the MMDR Act.
There is no
Framed
scope.
by whom?
By the government of India, but
No.
but Mahanadi Court fees doesn't fit into the MMDR Act. There are judgments of my lord. There's a constitutional bench judgment. There are some judgments of the high courts of different high courts, and also a judgment of latest judgment by my Lord Justice Vikramnath.
So let them take.
Very well. Your
Item-
lordships are fixing it on the 8th.
On the prayer of the AG.
Very grateful, my
It's a single word or two words
Lord.
which you uttered.
Pardon
It is a single word or two words.
me. I said very grateful. But these are 3 words as much as I.
No. Now you are changing your stand. You said only uttered one phonetically, one thing. So I said is a single word or two words?
No, but I was asking my learned friend that, we might require.
No, wise man argue the cause, no? Then rest is up to
Yes.
I don't bought up.
Then give it all. Don't.
Item 22.
Does that matter? And Milord, of course, Justice Raman was not there. My Lord, he was to sitting with Honorable Justice Das, directed for the and the other tribunals, the order to be
Yes. Oh.
see
No, the same thing. As we have, we have said, Rule 51.
Learned senior Milord was to give his opinion.
No, that is what if he completes his opinion about you.
No, sir. My Lord
No.
had observed that there was a conflict.
No, that is what I'm saying, that you have to complete it today itself, because this bench is only for a day. Actually,
Can I interrupt, my lords?
Oh. No, sir. Why you want to interrupt?
On the last occasion, a young
We
advocate was
remember everything. We remember everything. Last occasion, what?
a young advocate was sitting in that court. She, in fact, followed the proceeding and she wanted to assist your lordship. She is online. She is from Delhi, my lord. So since your lordship.
Oh, you wanted. We'll definitely. Yes, we'll permit.
She's Alisha Roy.
Yes.
Yeah, she's Alisha Roy.
Yes. We'll take care. Let the senior counsel first argue.
Yes. Sure. Yes.
Yes. Just wait. Let the senior counsel's view come. Then we'll hear you, Miss Roy.
Mr. Dole is very happy that he has expanded the horizon.
Yes. What is? No. It was a doubt which has created. Let us have the clarity on the doubts. Let's first the senior advocate, who is a veteran in the criminal jurisprudence. Let us hear his view first.
As because no specific query was put by my lord, and the order shows my lord was pleased to put a question that powers conferred upon the executive but also the implications thereof. That was the order which was passed by my lord. I have tried, my lord, to formulate 3 questions, but the way I have understood the entire Parent Act, MMDR, and minor mineral consistent rules. Whether the authorized officials are specified in Rule 51(2), like director, additional director, or joint director, deputy director, or mining officer, assistant mining officer, or junior mining officer, divisional forest officer, or assistant.
These are all executives.
Under Section 51 are to be considered as police officers for the purpose of these acts. I have framed a question, and I have answered it relying upon Constitution bench of the Honorable Apex Court till my lord Vijay Madanlal Chaudhary, where I have also quoted the relevant paragraphs where it has been held that they are not police officers or officers under special acts. They are not police officers because their work is very limited. Second question which I have framed: why were police officers included, added to the list of authorized officers under Rule 51(2) plus 2? That has been answered by Madras High Court. That also I have given reference. Third question comes up: whether magistrate can order interim release of seized articles or vehicles alleged to have been used in illegal mining activities as per Section 503 or 457 CRPC. But as statute says, as law says, it is to be reported. It is to be seen whether the seizure has been reported to the magistrate. When the seizure is reported to the magistrate assumes jurisdiction.
Correct.
Then on the facts of the case, my auditor can submit whether the seizure has been reported.
No, he just wanted.
If the seizure is reported,
Correct.
the magistrate assumes jurisdiction.
Correct.
If the seizure has not been reported, then I have given reference of 3. I have prepared a memo of citations of 3 judgments, one of our High Court, one from Madras High Court, and another from Kerala High Court, where Honorable Court, considering this fact, has directed the concerned authorized officer to report the magistrate so that magistrate can dispose of the application with the specific time has been given within 7 days, and in one case 2 weeks. If it has not been done, then magistrate assumes jurisdiction and he can dispose of. Because concession rules specifies magistrate is the sole authority.
Yes.
Magistrate is the sole authority.
Yes.
Rule 51(3) is very clear in that aspect.
No court shall
any mineral.
Yes, that is tree. I have seen that's tree by the court.
By the court.
That's true.
Court, because even that is before filing of the complaint or after filing of the complaint, it is to be reported to the near jurisdictional magistrate, nearest jurisdictional magistrate, so that magistrate has got power to consider the same. power of confiscation, power of release, everything which is with the magistrate. That is in short the answer to the query. Second vote.
No, Mr. Dol, what really troubles me, these are definitely a very ancillary questions which have come. But the main question was something different. Because what we find, you have gone through Rule 51 extensively, because that is the only provision which really, that creates a confusion or ambiguity so far as we are concerned. There are two aspects in the matter. Because you are under the criminal jurisprudence, the seizure and the confiscation are a two different concepts.
Yes.
A seizure can be done and confiscation is another aspect. So seizure can be done definitely by an executive. There is no difficulty if the statute provides such power. And once it is confiscated, then another concept that would come. Here the question was actually because in sub-rule 1 of Rule 51, this talks about that any person who have been found transporting the minor minerals or such and such in contravention to the provision of this or the illegal extraction, whatever, it is a cognizable and punishable offense under the criminal jurisprudence up to 2 years. Punishment is up to 2 years or a fine which may extend to 5 lakhs or both. So this power is conferred upon, I think, the magistrate, the court, because it is a 2 years punishment for magistrate tribal cases. So it is in that way it has to be done. So once this offense becomes a cognizable, now there are two aspects what troubles me, I tell you very frankly. An offense may be a criminal cognizable offense. An offense may also be a civil offense, both. Both. It can come. Say threat, perception. Then there are many other aspects. I can lay hand to one. Let's say under the Indian Electricity Act. The theft of the electricity or the pilferage. It invites both the criminal offense, it is a criminal offense, as well as the civil offense, where the provision is that the electricity or the distributor or the licensee, he can assess the loss because of such pilferages and make a preliminary assessment of that loss and can raise a demand and then recover it from the consumer. So both liabilities are there. There are many multiple cases where both are the civil and the criminal liability are there. Both can run together. Say another example of 138 of NI. Check bouncing is predominantly is a civil wrong. A person has to repay his money, but because of the act, this section, it is also criminal. And series of judgments are there that apart from 138 also you can file a civil suit for recovery. Both can run simultaneously because the consideration is different. What I find here is that it is cognizable offense also, and there is certain powers which is given upon the executives to seize. So there is no quarrel to that proposition that whether they can seize or they cannot seize. I think once the statute confers power, they can seize. I was thinking of when the word compoundable of an offense, if you compound the offense, then the question is who can compound the offense, executive or the court? Because offense once the offense is committed. What you are saying is that unless that offense is reported to the court or the magistrate, it remains in, say, medio for the time being. Then it does not.
That is with regards to the release of the vehicle. But with regards to the compounding of the offense,
I was grappling with that.
well, that language is very clear. Well, let me see. Rule 51 clause 4.
4 was troubling us.
Well,
4 was troubling us because here the compounding power, the power to compound an offense is given on the executives,
well,
which is a deputy director, a mining officer.
the offender will offer for the compounding.
Agrees.
Suppose a offense has already been committed.
And the offender will opt for compounding.
Yeah.
Then the question of compounding comes, man. That is the language.
Correct. Then who can?
Whether the civil revenue authorities or the.
Correct. That is the only question.
That was also troubling me because the language is.
That is what is there. Because it has been vested upon the executive.
Well,
compounding of an offense according to this sub-rule 4 is vested upon the executive. He can compound.
In Central Sales Tax Act also, there was Section 10 capital A. Penalty in lieu of this prosecution. That is 10 capital A, subsequently introduced. Section 10 enumerates certain offenses. And that also in the similar wording, there also no court shall take cognizance. Then you see sub-rule 3.
Any mineral, tool, equipment, vehicle, or any other thing seized under these rules in respect of which complaint has been filed under clause 3 of sub-rule 1 shall be liable to be confiscated.
By an order of court competent. That is where.
Well,
because of the one reason, because what I find is that 3 has to be read conjointly with the 3 in sub-rule 1.
well,
It says no court shall take cognizance of any offense punishable under this rule except upon a complaint in writing made by such officer or the authority mentioned under the clause. That shows that at times there may not be any complaint in writing made by an officer or the authority before the court, before the court or before the police, so that immediately the court will take a cognizance of it. So unless the court takes a cognizance of the matter, then in that event, the question of compounding an offense really raises a question.
question now comes up, whether before reporting to the magistrate, revenue authorities, those who have been authorized, those who have been empowered by the statute, they can compound the offense or not.
Actually, this is more specific. The broader one was, the first question was whether the executives have a power to compound the cognizance of the offense which is cognizable in nature. Let us see. Cognizable in nature. First. Second is, unless the cognizance is taken by the court, whether the executive can exercise the power. Because the word compound was really trouble us. It say if it is any other word than a compounding the offense, the position would have been different. But once they use the word compound the offense and then punishable, how to make a synchronization in that?
Then clause 5 also.
Because I think
nexus. Clause 5.
Can you have a CRPC? Let us see. The old one. I am not very much
BNSS.
BNSS. I have not. Where is the provision for this compounding?
Compounding 320.
Yeah, 320.
Madam.
If you come.
Compounding of the offenses.
Yes. It says the offense is punishable under the section of an Indian Penal Code. I am not talking about this.
Yeah.
It's specified in the first 2 columns of the table, may be compounded by the persons mentioned in the column. Oh,
You want to see the schedule?
I am looking at table.
Schedule, yes, first schedule.
Table. Oh, oh, no, 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 no. It was, anyhow, my understanding was,
It is the person who is,
yes,
who is the victim.
yes,
He can.
yes. I'm just getting.
But certain offences are compoundable by the court process.
Is there also by the court. If 20 itself is there. But subsection 2, 320 subsection 2. The offence is punishable under the sections of the Indian Penal Code specified in first two columns of the table next following name with the permission of the court. That question is gone.
Yes.
Another to become within manner the special statute has provided for compounding. Whether he can borrow from the general statute.
There is a both general specious or something that legal maxim is there that the special statute will prevail over the general statute.
Section 4 and 5 of the RPC.
Non-derogate.
Section 4 and 5 is clear in understanding. But here the gap which has been left by the draftsman while preparing this rule, that is to be filled up by mine. And through judicial pronouncement, I'll see to it. Because I was expecting this question as last week. When the matter was taken up by matter and will be, but in general, I could not cross that.
True.
Central substance.
But with regards to compounding,
Very interesting, because if you talk about this power that compounding can be done by those persons, but again the intervention of the court really comes. If you look at 5, Roman 5.
the accused has been committed for.
Now keep it in mind. I'm just giving. Roman 3 says no court shall take cognizance unless the complaint is given in writing. So it may be a situation where there is no complaint by the officer in writing to a police or whatever. So the court is not supposed to take a cognizance thereof. Then comes the question of 4, that is a compounding by an executives. No difficulty. Then come to 5. Very interesting. Where an offense under this rule is compounded, say by an executive. Let us see. No proceeding or further proceeding, as the case may be, shall be initiated against the offender in respect of an offense so compounded, and the offender, if any custody, shall be released forthwith. By whom?
That has also shocked me.
By a police officer who has arrested must be on the basis of a complaint. Then it becomes a cognizable offense. May not be the court has not really taken a cognizance. Maybe. How can a police? I do not know. No, we have to just find out. We have to harmonize the provisions, whether that is permissible. That's why we wanted.
By simultaneously, if they are making seizure of a vehicle and arrested a person, Lordship. So definitely they will restrict to the provisions under the CRPC.
So this arrest cannot be made in vacuum. There should be something in writing, otherwise they cannot have some kind of a complaint or some kind of a, or even if they went there, they have to come back and lodge. They have to record something in writing. So it has to be in writing.
And if the seizure has been made, it has to be reported as per section 102. We as quickly as possible
to
the nearest magistrate. That is 102 CRPC, and that has been taken note of in section 54. Minute.
Yes.
The rule 54. Rule 54.
Yes.
That section 100 has been used.
CRPC actually gives a mandate also.
Yes. We are still in a ambiguous situation.
And judgment, Lordship.
Yes, somebody was appearing. Who can lay hands? Yes.
Your Honor, on the last date of hearing, I was listening to Your Honor's questions, and I basically narrowed it down to the fact that once a complaint has been filed, and particularly once the court has taken cognizance, can the departmental authority compound the offense and unilaterally release the seized property? Your Honor, Rule 51(1)(4) expressly permits that the authorized officer can compound the offense either before or after filing of the complaint. This is actually supported by the judgment of the Supreme Court in Jayant versus State of Madhya Pradesh, where the Supreme Court recognized the validity of departmental compounding under special mining legislations, even after institutional prosecution. But there was a caveat to this, Your Honor, where they clearly say that it does not constitutionally and cannot bar prosecution for a distinct offense under the general penal law. Your Honor, apart from that, the major dissonance is between Rule 51(1)(4) and Rule 51 subclause 3, which says that in respect of which complaint has been filed, such property is liable to be confiscated by an order of the competent court only. And this creates an avenue for two parallel proceedings to take place. And here is where a harmonious interpretation of it is required, that it can be suggested that the department may compound after filing of the complaint, but before cognizance has been taken, Your Honor. And this, Your Honor, I believe is also consistent with the structure of the MMDR Act. The subclause, the section 21 of the MMDR Act, which can be considered as the parent act of the OMMC concession.
So that is always a parent act.
Yes, Your Honor. if
And
we were to
it is a subordinate legislation. There is no difficulty.
Yes, Your Honor. So if we can read it harmoniously to say that it can be done after filing of the complaint, but before cognizance is taken, it would be in synchronization with the MMDR Act. The section 21(4)(a) contemplates confiscation by the competent court. So seizure can be done by the executive, but when confiscation or disposal of the judicial process begins, it's entirely the judiciary who comes into play the role. And I think the bare reading of section 321 that Your Honor did would also align with this and the judgment of the Supreme Court in Shionandan Paswan. Your Honor, the judgment of the Supreme Court in Shionandan Paswan sort of highlights that consent requirement exists precisely to prevent the executive power from being used to terminate a matter that is already before the court. That once cognizance is taken, the matter can be considered sub judice, therefore before the court, and thereafter any compounding that has to take place can only be taken with the permission of the court. Your Honor, Jharkhand also has a similar rule, which was actually struck down in the case of Aditya Enterprise versus State of Jharkhand. This is a Jharkhand High Court ruling in WPC number 6788 of 2023. They challenged Rule 11 subclause 5 as ultra vires, that they do not align with the parent MMDR Act. And precisely because Section 21(4)(a) of the MMDR Act reserves confiscation of seized property to the court competent to take cognizance of the offense, the state argued that it cannot be in consonance with it, can't be congruent to it, and thus has to be struck down, which was done by the Jharkhand High Court, Your Honor. Your Honor, similar situations arise in cases in international law as well, where there is strict separation of power. But since India does not believe in the concept of strict separation of power, we have to understand what can be considered as an essential function to the judiciary. And thereby, I would like to believe that once a matter is sub judice, it becomes an essential function of the judiciary to take in account whether disposing that matter off in terms of compounding would be in the best interest of the public, Your Honor. And thereby, even in the United States, in the United Kingdom, and in Australia, they have a check in place in which if the public prosecutor wishes to withdraw the complaint, it has to be first put forward before the judge, and only when he agrees can the complaint be withdrawn. So, Your Honor, my suggestion is very limited to the fact if the section could be read as it is before or filing of the complaint, but if we could add that it has to be before cognizance is taken by the magistrate, then I think the clash between Rule 51(1)(4) and Rule 51(3) becomes a little easier.
Okay. Yes. Thank you.
Thank you, Your Honor.
Yes. Yes, she has suggested that something has to be harmonized because we have to interpret the statutory provision in such a manner that it will render it workable than to render it osseous. So either a purposive construction, or if the literal construction really offends that particular core fabric, then we can definitely go for a purposive construction, that what is the intention of the legislators behind incorporation thereof. That is what is saying. What it says is before or after the filing of the complaint means that yes, it can be done after the filing of the complaint, but restricted to before the cognizance is taken by the court. If the court by mere filing a complaint does not mean that the court has taken a cognizance there.
Yes, sir.
It's true. What he says is that in between that interregnum, this power may be reserved with these executives to compound the offences because they will not proceed on the basis of those complaints. And once the cognizance is taken, then their power ceases.
They are focus of issue after the cognizance is
taken. That's a harmonization, appears to be a rational and reasonable view.
that can happen. Reading that.
Because the word compounding the offense has been very loosely interpreted in this way. Actually, if you think, because it is within the domain of the authorities not to proceed with the complaint or under the criminal jurisprudence if he pays off all his liabilities towards that. So that is what is the I would say the succor which has been given to that offender. I think it's a food for thought, definitely a good food for thought.
It will be taken up on first.
First, no, we are sitting only on, yes, Tuesday, yes. Then take it on first, yes. Thank you, madam, for your valuable suggestion. We'll definitely see to it.
Thank you, Your Honor.
Yes. In this matter on 21st, on first.
The next two items are
okay, say that. Till then.
Item 23 and 20.
They will take care of that.
They are taking good care of. They don't have to. At this point is more important.
December 9.
Yes.
Is
Item
it
number.
fair? Is it fair?
Yes, item number
23.
It's wrongly come. It is directed to be listed on 8th September. That's the order.
Yes, madam. As per the last order, additional affidavit had to be filed.
No, I filed an amendment actually. Mistake on my part.
No, come on 8. Let it appear. Because there is already an order, it should not.
IA 16.
Please give, that will be tagged.
Yes, sir. Great.
Item number 24.
Huh? It should. Yes, this is also to be listed on 8th. Wrongly it has come.
Item number 25.
Yes.
Period of leave, the beyond 5 acres or not?
Yes.
This is for production of the original auction notice.
In fact, that ship is already.
To ascertain whether
That ship that will be extended till that ship 31st.
there was a registered agreement.
Because of
So this we have heard with the other bench.
Yes.
No, let it appear tomorrow. It should not be heard.
Item number 26.
Oh, tomorrow means Thursday.
Item 37. It's really don't rework plan. Item number 37.
We are hurriedly moving. I think most of the matters. Item number
26 now.
here.
Item
Is it
26.
before this bench?
Before this
No. Before this bench, it was heard.
Yes.
No, that
The composition of this page.
No, I'm just thinking we are really sitting here for a day because there are certain matters we virtually heard it. But because of one or few things could not be completed. For that reason, we said. When you come day after tomorrow?
This is one of those cases.
No, it was not heard by this bench.
Yes.
Then show me.
Yes, sir. Because that and the lordship in fact kept reserved for orders. Lordship wanted to.
No, it is for with Justice Das, not with Justice Raman. Last order you see.
It is, well, I think it was
25th August was reserved for orders.
again thereafter will add there are two. When they
No.
were sitting, but this date has heard will add.
No.
December
Sure.
12th will add.
Oh, we have heard it. Now, Justice Das, we will be dictating the judgment in the open court on 27th. Come on, with Justice Das.
27th and after.
Oh, your junior will be there. We will be dictating it. You want your name to be recorded? When? 29, 28, 29. Come on, 29.
Yes, 29.
29. Yes.
Yes. We are working on 29th. Come on, 29th. Yes.
Item number 27.
And applause. Next week. Yeah, after 2 weeks.
Item 28.
Your Lordship, I have filed this IA for extension of time. Your Lordship, may kindly turn to page 12 of my IA, the operative portion of Your Lordship's order.
Page?
Page 12 of my IA. Your Lordship's
IA is flaggy.
Flagging.
What extension you
Your
want?
Lordship, in the meantime.
There is no page 12 in the IA.
Your Lordship.
Oh, yes, it is.
13, Your Lordship.
Paragraph 13.
Your Lordship has paused and set aside the matter with a direction to pay the refund
Yes.
along with interest
Correct.
in a period of 4 weeks.
4
Your
weeks.
Lordship.
Yes.
According by that order, we have issued the letter to the GSTA, and accordingly some time was required. Your Lordship, for that reason, I have filed this IA. However, in the meantime, we have granted the refund by the order dated 5th June.
So it has become infructuous.
Only since 1 month
Yes.
belatedly we have granted. For that, one line Your Lordship may dispose of.
by
all the four petitions are same. 4 cases of it.
You have already done? You have already paid?
Your Lordship, 5th June.
Till the date of the remittance, we have already said, yes, all four. Yes, four cases.
Item note 29.
Jadam Wallace. No, opposite.
It's filed modify the automated proceeding 7/2000.
Have you served the copy? Have you served the copy? Yes.
Just a minute. I feel ill-equipped to assist your lordships today because I did not expect it to be taken up.
Why?
Because of the noting in the list. Because what has happened is there are 5 or 6 matters which are clubbed together. As far as
And this was substantially heard by this bench.
Yes, well, it's true. But when I saw the status of my case, particularly my one of my matters, that, my lords, your lordships have been pleased to condone the delay. Thereafter, my lords,
Now it says you argued it, everything was within your knowledge, if I correctly remember in the morning.
I thought that
Mr. Raute was very much vocal in this regard. He says that you have argued and now you are saying that
Not argued
no
once.
notice.
Argued.
No notice.
We made the argument now. What I suggest, keep on running.
If he is inconvenient, we are keeping it on first.
on first.
That's the first available Tuesday.
Yes. I know.
First, that's all.
10:30.
10:30.
Yes. Great, sir.
Yes.
My lord, DW number 3984.
Yes. Imagine, Mr. Raute.
No.
Tag.
Whatever judgment will be passed, that will be over.
Yes.
All these
Tag. W6059.
Judgment comes, then everything will be fine.
They are not listed. That's tag.
It will be covered by that.
That's it. Yes. Unless the people really will say that.
Will you argue or will you adopt there?
No,
Tell me. Adopt, then give it. Record his name, submits that the another matter in
Q31.
About the interim order, my weekend. Interim arrangement, we continue. No order is there.
your clients are there.
Every
No, we have already passed the order. The senior Mahatma is appearing. That's why I thought that somebody, unless he opens his mouth, otherwise he cannot justify his appearance.
Because they told
No.
Item number 31.
Wait, please, the lordship, this matter has come from IAF, where I pray for a modification of the writ petition as well.
Have you served the copy?
Yes, yes.
What do you say?
Modification of writ petition. Can we
First
do?
title of the writ petition.
How can we?
It had put in typographical error in the.
What is that?
After disposal of writ petition.
My lord, in order also it was reflected.
What is? No, in your writ petition it is wrong or order?
Yes, my lord. Both, your lordship. In the
What do you want?
for Kumusi, Messrs. Kumusi SCS Limited.
Oh, it has gone to Kusumi.
Yes, your lord. Yes, your lord. It says mentioned in Kusum. In both the.
It should be Kumusi instead of Kusumi.
Yes, your lord.
One S and is the difference. That can be done. 152 we can keep. Or 153 we can also do.
Order we will move it. We cannot touch the writ petition. And order.
CPC तरह. Yes, only order we.
Order the IA is fine. Hala?
Wakalatnama is executed by whom? Let us see. Where is the Wakalatnama?
Secretary of.
No, where is the stamp?
No, it is proprietorship.
Well, it's a society.
Society. Kusum.
No, where it is written?
Here,
I just wanted.
Here. Kusum.
Kusumi.
Yes. But while preparing the cost, that
No, Kumusi. No, it is also wrong here.
Achha.
He wanted a Kumusi.
Kumus.
But your Wakalatnama is Kusumi. Then
Everywhere it's mentioned as.
no. It is a handwritten. Where is the authorization letter by him to him? Have you annexed?
No.
Is a society? You don't.
Here's the sign for the second. He being the secretary of the society.
This cancellation is Kumusi.
Kumusi. IA Kumusi.
No. No. Eviction one is also Kumusi. Yeah.
Perusal of registration certificate, it seems the name of the petitioner is Kumusi instead. We will submit the
So my lords, this is the factor where my lords had recalled the order in review because the review was dismissed. And my lords had said that there is no delay because the original order was challenged. My lords had then come to the conclusion there is indeed delay and recall that order. I had challenged my lords both the dismissal of the review as well as the original order in the writ.
Challenge means
I challenged both the order of the review petition that was dismissed for delay, as well as the original order that was challenged before the Honorable
in one appeal.
My lords, one appeal. My
Now
lords
tell
said
me,
dismissed
is it competent?
My lords,
Tell me, is it competent? Because the review is not an appellable one.
my lord, which is my lords that since both orders were challenged in the last order, my lord had recalled that order where the review was challenged, and the appellate order is still there.
Correct. So you wanted to challenge the appellate order.
Fine, that's already challenged. And my lords had directed my learned friend to file objections to the condemnation of delay application. He has just given me those. Right now, he has handed me a copy of those objections.
So you want to file a rejoinder?
No.
I have found the copy.
Yes. What do you say?
There is a delay of 484 days, madam, without any proper explanation.
Without any proper
Yes,
explanation.
sir. Ultimately, the para 2 and 3 of the petition, 556 up to 26.
Yes. And this flag.
556 up to 26. I don't know.
No, condonation application.
flag D.
Flag
D.
D.
Yes.
Yes.
In fact, my lord said on the previous occasion, he looked at these two paragraphs and directed him to file objections because he said he'll file. My lords may recall that there are 7 writ petitions filed from 1992 until 2024. And apart from that, my lords, the whole controversy in this appeal is in two sentences. I'll place.
Sir, if you were a fence sitter watching a particular proceedings which are pending in the court, just to see that what is the outcome of those proceedings.
No.
And ultimately, that is your paragraph 2.
No.
And then after looking at it, then you came.
No, what I mean to say, my lords, is this, that in 2 lines, my lords, the opposite party, private respondent here, what is claiming is RSCP benefits of a post that they never worked in. Now, what my lords in the single bench has done is, because some other people working in the Bhubaneswar Municipal Corporation had been granted those benefits illegally, those benefits were granted. He sought parity on that account and he sought for those same benefits. When he was transferred to Cuttack and we wanted to give him the same benefits, we examined the matter and realized that he never worked in the post for which he is claiming the benefits. And surprisingly, my lords, in 4 writ petitions successively filed from the year 2016, all of those were disposed on the basis of representations filed. Nobody has ever gone into the merit of those writ petitions and decided whether the respondent was actually entitled to the benefit or not. Which is the reason, my lords, we are forced to challenge, because the CMC audit said that this is not admissible because he never worked in the post for which he is claiming, and that issue was never decided. The writ petition was dismissed only on the allowed only on the basis of the representation. We did not file a counter. No opportunity was granted. When we examined the entire file starting from, my lords, 92 and also examined the office records of the BMC on what basis it was granted, we realized that it is not admissible. That's why finally we have come to my lords. And unless my lords decide it on merit, my lords, we file a counter. It's decided, my lords, that he will keep on taking the benefits which he never had accrued with.
The revised scale of pay rules are not applicable.
Not applicable because he is claiming the RSP benefits for the post of a junior assistant. Whereas he was admitted to the post of junior assistant only in the year 2015. Before that, he was working as a tax collector. So what RSB benefits he could have claimed was the benefits of a tax collector, not the junior assistant. He is claiming the benefits of a junior assistant that is granted to him. That is what we are challenging.
Yes.
So far as the IA is concerned, I have submitted my objection. And so far as the merits of the case is concerned, my lord, the respondent was initially appointed.
With course.
This one first, come and argue on merit for the time being. We're keeping this condonation aside. We are not assuring. Let us understand the main core. I think the issue. Let us understand. But thereafter, we think whether the condonation justified, not justified.
Only wanted 3rd of September.
Because sometimes the merit of the matter also is an important factor. So let us see.
Keep it on 3rd
First.
September.
First.
Yes.
What I only pray is there is an application from my side for additing additional documents because there was no counter.
No.
So what if my lords commit that day, I will only hand over resolutions which are not there because I could never pay it.
No.
I'll file an additional affidavit to that effect. Or my lord.
Objection to the
Application for additional evidence is also filed.
My
You filed.
he has already filed an objection to that. He's given
No. Out of 4 IA applications, I have submitted only 2 objections today. On the next day, I will file my order to.
We'll consider that.
You can be permitted to produce additional evidence.
What I seek, my lord, the only government resolutions and orders of this honorable court that my lord may accept.
Question is not that.
My lord.
Under what provision of the law, additional evidence can be taken?
No, my lord. I mean, this has not yet been allowed, so my lord, I have no.
There must be a provision which permits the additional evidence to be taken. That is under order 41. The word additional connotes in addition to what the evidence has already been given. If you have not given an evidence in the trial court, then you will be permitted to schedule the additional evidence.
What has happened was, my lord,
I'm asking you simple.
No.
What is word additional connotes?
Relevant.
Litigation is decided on an affidavit evidence. If you have not filed any objection or a counter affidavit, can you, as a additional evidence, can you produce?
Ordinary course I could not, but because my lord's a hearing merit, then those documents.
No, sir. It's so easy. It's not so easy.
Then what I'm only submitting, my lord.
Come on first.
My lord.
That is.
public document can be marked as an exhibit provided it is shown as a secret.
The substantive justice is involved, which is my lord, but my lords may decide on the first. If those resolutions are important or not, I'll hand them over, I have them. And this honorable court also.
The only exception is public document you need not have to prove
My lord.
as the other document.
My lord.
The privilege.
My lord. I'm confident.
Nothing more than that.
If my lords feel it necessary to look at those documents, then my lord, I'll hand over.
Item 33.
It's more a mercy application, man. It's more a mercy application. The reason being, 13-4 auction in surfacing, challenged in DRT with a delay. DRT dismissed it. They went in appeal. Appellate tribunal allowed it and remanded back to the tribunal to consider the limitation application operation. Now the other side challenged it before this honorable court. The honorable coordinate bench in the judgment said that section 17 application, since there is no contemplation of section 5, they have no authority to condone the delay. But in my humble opinion, that's an opinion not correct, because section 29(2) of the Limitation Act, section 24 of the DRT Act, section 17, they are all not taken into consideration. But they leave it aside. The reason being that judgment was subjected to review. Review dismissed, went to Supreme Court, dismissed. But only saving provision the honorable coordinate bench said is the question of law is left open to be decided. So that is how the applicability of section 5 is yet kept open in this judgment. So they are not on that. But they are.
Is it original proceeding or is it ancillary, supplementary, or incidental proceeding? Section 17.
Section 17 is an application.
I'm
It can be.
I'm talking about is an original proceeding or is
it's original proceeding. It's an original proceeding. It's not supplementary.
It is an original proceeding. Whether the Limitation Act will apply.
Limitation Act will definitely apply because NHI Act, the Popular Construction, whatever judgments are considered here, they are. The provision itself says that 45 days limitation not thereafter. The penal clause is there. Like Arbitration Act also, not thereafter.
In section 17, whether any provision is there for condonation?
No provision for condonation.
No limitation for 17.
Limitation 45 days is there. If your lordship sees section 29(2) of the Limitation Act, this being a central law and a special law, section 29.
I'm just thinking in a different line. There is one judgment which troubles me.
I have got some judgments also subject to.
No, that is a directly on the point. If a proceeding by way of an application is an original proceeding because the registration is done on the basis of an application.
Into that of a shoot, your lordship proposing.
Akin to
that of a shoot, there is no problem.
Akin to a claim, and if it is an akin to a claim, then it is a suit and limitation.
Look, this is not a shoot. This arises
applicable not 29.
In that case, this is not akin to a shoot. This arises out of 13(4) proceeding.
Proceeding not before the DRT.
But statute says court to.
I'm just trying to recollect the judgment.
But my humble submission would be.
The deputy director.
I'll examine that. Gautam Adhikari or Gautam Rai? Just
I tell you the fact, it originated from the other state.
Yes.
There is a West Bengal Land Reforms Act 1955. Section E permits a right of preemption in case any agricultural property is sold by a co-sharer when preemption application lies by, I mean, the Bhakchas, whatever the organization, we call it a Bargara.
Bhakchas.
And then the Mosherer.
It's combining preferred appearance of the order.
It says Revolution Act.
It's the order.
Question arose that after that period, if an application, because it also talks about application, an application, not preemption. If an application is made, whether it will be the section 5 applies to appeal application, no difficult. Yes, whether section 5 applies. First view was yes. The Supreme Court in that judgment says no. Because it may be an application, but it is an original proceeding, neither supplemental nor incidental. So in that event, being an original proceeding, it has a trapping of a suit. Once there is a trapping of a suit, section 5 does not apply.
No, of course, I have not applied my mind in that line. I have
What
not
I'm
applied.
saying, this is what origination is on an application. There is no doubt. You are also talking about section 17 and application. But if it is an original proceeding, for the first time it is registered, not incidental or a supplemental as in the civil procedure court. There is a category of the incidental.
Yes, yes, it is supplemental, incidental. There are. Thank you. Not one. There are at least 12 Honorable High Court's judgment in support of applicability of section 12 Honorable High Court judgment, Gujarat, Andhra Pradesh, Assam. 12 High Court judgment I have.
Examine section 17.
Our High Court judgments are also, our High Court judgments, divergent view, the cleavage of opinion is there.
I'm talking about the Supreme Court. That's why I'm saying.
But Supreme Court judgments are also there in my favor of my opinion.
No. Section 17.
Yes, they're there.
Section 5 applies.
Yes.
Then no question.
But that issue is kept open.
Give the section 5
I did not toil on that point. The reason being, the division bench, the coordinate bench has kept that issue open. So I am not agreed there now.
You say Supreme Court that
your lordship did not labor on that. The reason being, I am on a different aspect now. My review was dismissed. I was given only 8 months time or 8 weeks time to vacate the premises because the auction highest bidder is there. Now my review dismissed. If they went to Supreme Court, SLP dismissed. Now the order passed by the coordinate bench of this Honorable Court got affirmed up to the Honorable Supreme Court. So with that, the Honorable Division Bench of this Honorable Court has dismissed my limitation application on merits. That's the point. So question of law is on the one side. They have rejected it on merits, saying that the explanation given is not sufficient.
No, that I understand section 5, they have entertained. Now,
Yes.
as an appellate court, if we
No, not an appellate court. Your lordship is exercising the same jurisdiction of the Honorable Division Bench. It's an application only for extension.
Review.
Not review dismissed.
No, what is
It's only an application seeking extension of time because my father is suffering from cancer. That's all. That's why I say it's a mercy petition. Everything is lost everywhere.
Oh, this case is with Justice Das. The original order is with Justice Das.
Lord, my problem is 25th of August, date is expiring, they will take over position.
25th is today.
Yes, today only last day. If I do not get 1 day extension even, tomorrow they will vacate me from the only residential house. Only residential house.
Maybe you have suffered, Why you have put your residential house as security?
They do it.
So,
but I only need some time because the father is suffering from cancer. I need some more time.
I understand.
I only need some more time, Lord. Therefore, I said
consider sufficient time for that.
Beg pardon, Lord.
You were
no. Earlier, not on this ground. I hope.
No. On 25th of June, when your review was.
Yes, they have given me 8 weeks time. And today is the last day.
What more?
Today is the last day. Your lordship may give me little more breathing time only. That's all. The only house they will take over. I leave it.
No. It should be done on 27th. 27th.
I leave it up to your lordship, Lord. But then
he has disposed of the petition.
Yes.
Review. So it has to be heard by him.
That's fine. But they'll not evict me by tomorrow. At least that's why protection will be given to me.
No.
Well, there no point will, if they evict me tomorrow, day after tomorrow, there will be no point to decide on price.
We do not want to actually dismiss it in that sense.
Lord, that is okay, Lord. If it's dismissed also, he will understand that my application is dismissed.
So let us a breathing time if they could not mobilize their resources tomorrow.
There is speed.
Item number 34.
Recovery officer is there?
Yes, bank is there. Bank is there. Only I need some.
I am for the option purchaser, he for the bank.
Has
Like
not received
tomorrow
any
is a
copy.
holiday. Tomorrow is a holiday and lordship
Copy I have
fixing
not
it to day after tomorrow. So in fact, tomorrow nothing is going to happen.
Then
We
let-
can audit.
then let-
You serve the copy.
I have not filed, he has filed application. In fact, I have not.
He is directing them.
Item number 34.
Item number 34. Matter relating to, we have questioned the validity and legality of amendment Odisha elementary cadre rules, whereunder completely the TET qualification has been exempted, absolutely. And it governs, it governs under the judgment of the Anjuman Ishat Malan. That your lordship, other day it was last occasion debated, and my lord was pleased to put certain questions on while we argued by relying the constitutional bench judgment. In the event all those provisions goes declared as ultra virus, then those who have already got promotion, that is 31st March 2019, on which day these provisions we have questioned its correctness, came into force. And those who have got promotion after, whether they are to be protected under the doctrine de facto doctrine or not, by relying that 81 judgment. And now in the meantime, what has happened? Well, state government had also filed, like of other states, review petitions and clarification petitions, even the read petitions, before the Honorable Supreme Court, saying therein, in essence, that those who are appointed prior to commencement of the RT Act without that qualification, and they failed to acquire within that cut-off date of 5 years, thereafter extended period of 4 years, that is in total 9 years, by 31st March 2019, they may be exempted from TET. But which in the review petition, a judgment was passed that has I have also filed both the things. At Bhag L it has come in the case record that they hold no, it cannot be, because the Central Act consciously in its amendment used the word teacher in position, and earlier it was teacher at the commencement of the act. With 5 years was a relaxation given. Thereafter, in 2017, provision to section 23 was amended, whereunder it was specifically second proviso was inserted with giving effect to from 2015, because it came into force 1/4/2010. 5 years ended there. From that date, 4 years was added. Using the language teacher in position, they all have to acquire the qualification. Otherwise, they will be removed. And the Honorable Supreme Court in the Anjuman Ishat case, while holding that it is a mandatory qualification for appointment and even for continuance. Otherwise, those who have at least 5 years of service, if they want to continue, they have to acquire. Otherwise, their service to be terminated and terminal benefits to be granted in accordance with the laws, state laws governing the field, if any. And subsequently, no right to be consideration. It was held that if I will draw just to refresh the memory, may I draw your lordship's kind attention? K. Flag K is the judgment, madam. Only 4 paragraphs I want to bring to your lordship. Flag K.
Which matter?
There
are multiple matters.
First matter, madam. That the Prakash Chandra Vishi, where the all non-OTT candidates, they have intervened, and everything has been, pleadings have been completed, citations of a final judgment has been cited, written note, everything has been filed. Flag K, that is Anjuman Isad E. Delema Trust versus State of Maharashtra and others in civil appeal number 1385 of 2025. The various questions was formulated, and the main question was whether the teachers, those who are appointed prior to commencement of the RCFC Act, that is in short RT Act, whether they are to be exempted or they are to be.
That is in J.
Malad.
That is the category, the indexing has been done.
Yes, Malad.
So I think it is a Roman 6 J.
Malad.
Page 88.
Yes, Malad. J. Applicability of TET to in-service teachers appointed prior.
88.
Malad. Teacher eligibility test, Malad. And your lordship, then your lordship will find also the relevant portions of the paragraph, Malad. May I draw your lordship's kind attention? Of that judgment 108, paragraph 214, at page 108, in bottom the.
No, it is not that same. It's an internal page 2.
And the entire judgment I have given under flag K. If your lordship will look to the flag K entire judgment, then the bottom portion page has been marked.
Then it is not a applicability. Yes.
Marked. May I read, Marked?
No, you are reading from which page?
Page 108.
Yes.
Of the judgment page, man. Paragraph 214.
Yes.
For the detailed discussions above and resting on the same, we hold that the provisions of the RT Act have to be complied with by all schools as defined under Section 2N of RT Act, except the schools established and administered by the minority, whether religious or linguistic, till such time the reference is decided and the subject to the answer to the questions formulated above under Section VII logically. It would follow that in-service teachers, irrespective of the length of service, would also be required to qualify the TET to continue in service. Dear Lordship, may I read also 215. We are mindful of the ground's realities as well as the practical challenges. There are in-service teachers who are recruited much prior to the advent of the RT Act and who might have put in more than 2 years or even 3 decades of service. They have been imparting education to their students to the best of their ability without any serious complaint. It is not that the students who have been imparted education by the non-TET qualified teachers have not shown in life to dislodge such teachers from the service on the ground that they have not qualified TET would seem to be bit harassed, although we are alive to the settled legal position that operation of statute can never be seen as an evil. 216 paragraph. Bearing in mind their predicament to invoke our powers under the
Oh, I understood. What is the report says that so far as RTE Act is concerned, once it prescribes the eligibility criteria that you must pass the TET examination. You must have the TET.
Yes.
Then you can't be appointed. Now the question is that there are many people who have already been appointed before RTE Act came into force.
Yes.
It came at a later point of time. Then he says that I understand that there are certain people who are there, but that does not really make them out of service. They have to just qualify for TEP as well. Then third question was, suppose there are many teachers who have already spent more than 2 decades or 3 decades. Their service tenure is left, say, less than 5 years. Save them. It says that they are not required to undergo for this TET because their tenure is within that. Somebody whose tenure is more than 5, then in that event, if they do not,
then they cannot be thrown out, but they are not entitled to any promotion.
No, my lord, I am just
Look at 16.
That is not true.
263.
Yes, my lord. Bearing in the mind, they are predicable.
Predicament means those who are appointed earlier.
Yes, my lord, earlier.
Then
My lord, we invoke our powers under Article 142 of the Constitution of India and direct that those teachers who have less than 5 years of service left as on date may continue in service till they attain the age of superannuation without qualifying the TT.
this is what I said.
Well, yes, those who have above 55, my lord. Just 5 years left, man.
I am not going on an age. I am simply going that those whose service tenure is less than 5. But I mean, who is going to retire within 5
Yes,
years.
ma'am.
Did not.
And they attain the age of superannuation without qualifying the TT. However, we make it clear that if any such teachers having less than 5 years of service left aspires for promotion, he
Then
will
he will
not be
considered for promotion.
not be considered without here having the qualified TT. Then 217. ma'am.
Correct.
In so far as in-service teachers recruited prior to enactment of RT Act and having more than 5 years to retire on superannuation are concerned, they shall be under an obligation to qualify the TT
Within 2 years.
2 years from the date in order to continue in service. If any such teachers fail to qualify the TT within the time that we have allowed, they shall have to quit service and they may be compulsorily retired and paid whatever terminal benefits they are entitled to. We add a rider that to qualify for the terminal benefits, such teachers must have put in qualifying period of service in accordance with the rules. If any teacher has not put in qualifying service and there is some deficiency, his or her case may be considered by the appropriate department in the government upon representation being made by him or her. Then 218, subject to what we have said above, it is reiterated that those aspiring for appointment and those in service teacher aspiring for appointment by promotion must, however, qualify the TT or else they would have no right of consideration of their candidature. 218 is the important. But my result submission before Lordship is even the qualification as prescribed in exercise of power under section 23(1) by the NCT, the prescribed authority, that holds good and that has been initially relaxed for 5 years for the in-service teachers, those who are recruited prior to commencement of the act. Thereafter, 4 years up to 31st March 2019. And after 31st March 19, even the central government issued a notification in exercise of the power that those who will not acquire by 31st March 2019, their service is to be terminated. And now, in different states, what the state government did, even in the particular case was, leading case was the Madras, there the law was framed exempting all the TT qualification. That was challenged in the civil bench and division bench, thereafter brought to the Honorable Supreme Court. And along with the other batch of cases, this matter was decided that there was also issue that teachers, their argument was the teachers, those who are seeking promotion, they may not, but they can continue because they are appointed prior to. Here, in the conclusion, by making an analysis in the entire body of the judgment, the Honorable Apex Court concluded, even if they want to continue in base level, they have to acquire the TT qualification within that extended period of time, which was granted in exercise of power under Article 142. Well, now what happened? Thereafter, the state government, like of the other states, they filed review petition or some file also clarification and read petition under Article 32 before the Honorable Supreme Court. In that batch of cases, Lordship File L that I have filed, there it was extensively debated and it only upholding the entire judgment, the Honorable Apex Court looking to their grievance only extend 1 year addition to the 2 years period. Now the judgment was delivered on 1st September 2025. It was extended to 1st September 2028. Now, in our state, what has happened?
1 year.
Yes, earlier 2 years plus 1 year. That means the 3 years. It will lead to the 1/9/2028. 1/9/2025 is the judgment.
When this judgment for 2 years is passed,
Malad.
September 1, 2025.
Yes.
Yes.
Then 2 years was limitation.
Yes.
And the in the review judgment, entire efforts at the instance of different states was those who are appointed prior to RT Act, they should be exempted. But court turned down all those arguments.
1 year, so up to 28.
Then, Malad, my respect to submission before Lordship is here. What is in our state, the before commencement of the RT Act of 2009, in exercise of power under section Article 2309, Governor has already framed a rule. That is, your Lordship may kindly have glance. That rule was amended twice in 2014 as well as 2019. 2019 amendment came just after the expiry of this 9 years relaxation period, as was granted under the Act. That is after 31st March 2019. That amendment was brought intentionally and deliberately in contraventions of this Central Act amendment. That is 2017 amendment. My Lord, may what in the amendment inserted?
Then what? Thereafter?
Therefore, the different provisions was inserted by of amendment, giving advantage to the teachers, those who have failed to acquire the TET qualification to get promotion from one level to another level. Under the cadre rule of 1997, the earlier it was level, it was of 6 levels.
You are the category of the teachers who was appointed after RTE Act came into
Yes,
force,
madam. Yes, madam.
TAT.
Madam.
So you do not want your earlier senior to continue and
No, madam. My respect to
you have an
submission.
easy path for a promotion.
No, madam. That is my respect to submission before Lordship is, madam, here, what the amendment brought, madam, that I want to draw your Lordship's attention.
There, the Supreme Court has said 3 years period is still there, 2028.
How could they will get the promotion? I have questioned the legality and validity of that provisions. I have challenged the virus. It contrary to the Central Act, so also the rules, even the state rules, and also the Constitution, madam. Article 21A. Madam?
What contravention?
Yes, madam. Your Lordship means
What is the contravention? Supreme Court judgment has come, which supersedes all the directions which have been passed. It has not said that subject to the rules framed by each of the state. It is uniform in the sense that the TET is indispensable. Exemption is only when any teacher is going to retire in 5 years. It says that if you do not pass it, qualify it, then your service will be terminated. And unless you have a TET, you are not entitled to a promotion.
And even they are also not entitled to continue after the expiry period.
So
even for the best at the best, but what has happened here?
Expiry, according to your stand, is in the year 2028.
No, my respect.
We are in 2026, sir.
No, Malad. What they are
may qualify tomorrow.
The question is,
some may qualify in the next year.
Malad, the question we have formulated, you Lordship may kindly have glance.
Forget about the rules. We are not going into the rules. This is what a
rule has made them, Malad, without TET qualification, rule has given them advantage. They should be promoted. That is why we have challenged.
Has the promotion taken place after this judgment? I am simply asking you.
Yes, Malad, in the process, state of process, they have issued.
You go there, say that defying or in a complete defiance to your mandate, they have done it. The state has acted.
Malad, let me complete. Malad, my respect to submission is here under the Malad, your Lordship will find teachers appointed against the advertisement published prior to 11 to February 2011 are exempted from passing Orissa Teachers Eligibility Test 1 and Orissa Teachers Eligibility Test 2, paper 2. And under the that is inserted in the seniority and gradation list. Thereby, the non-TET teachers, those who have failed not once, twice after attempt, they are getting seniority over us and they have been promoted even 2021, 2023. That's why we have approached from 2022 and onwards.
Representing those teachers,
That all the interveners,
where are they? Who is representing them?
but they are they have all
representing them.
They are in large number, but they have appeared in this present case and they have filed their counter. We have filed rejoinder.
Who is representing them?
They will not, your lordship may cause list, many of them that
They are not present today. Court, that is what.
Because you started arguing and somebody was just keenly watching you, I just thought they may be appearing, but you have to ensure that other sides are all here. So it's, you suddenly exerted your right of audience and then you started.
But the government is also defending them, madam. Government and their stand now, although government stand is contrary to their own retopic. But what has happened?
To understand, can we dispose of the matter in their absence?
But they know very well now the position of law has been settled. That is why they are in matter is least malad.
We'll simply consider, that's true. So you want an ex parte disposal to be done?
No, that I am not saying.
The next year, next time is they come.
Let the government answer.
Prevented. So,
let the government answer. They have not brought this matter on mention, that on today. It is in least malad. It is their duty. They are contesting. In their presence, matter was extensively hard.
We will dispose of in their absence.
No, but that is not my endeavor.
We don't think, we don't know if they come for a recalling, showing a genuine ground, then we can.
But now, my lord, what has happened in our state? They have prepared the gradation list by giving top placement in the gradation list of all non-TET teachers. They are not adhering to. It is one. Two, my lord, another factor your lordship will find.
Who is for the state in the matter?
And for the state.
Yes.
My learned friend has put something on affidavit referring to the review petitions filed by the state which have been disposed of. But that affidavit, let him submit that.
And I have not filed affidavit, just I have submitted by way of sound copy.
And regarding the promotions, the submission.
No, he is talking about that review application.
Well,
now you said that on what ground the review is sought. They may have a different ground.
Yes. But
so that's why I say that you have not placed the review petition which they filed before the Supreme Court.
But even the review.
Did you file a review application before the Supreme Court?
But so far as my knowledge, I only perceived from his argument that a review was filed and some order has been passed. And he has put that on affidavit.
Extending another 1 year. Another 1 year. So it's also to him also. The time period is up to 2028. 2028.
You acquire that.
So now we are in 2026. They may acquire that level. This one. What he says is that so long that PET is not acquired, you cannot promote them. Right. So now the promotion is the main concern. Because they wanted a easy walkover.
Yes.
On the other candidates who may ultimately qualify a TET.
But here is a case where promotions. But here is a case where promotions were earlier effected. Some persons have retired in the meantime, and and the argument today that is being advanced that in the meantime we have also prepared a gradation list including those persons, those who have not acquired the TET qualification. Let him put those things on affidavit so that we can.
This is what an argument is advanced without reading. What are you talking?
But now, today he is saying that gradation list are being prepared without resorting to the judgment.
There that you are preparing a gradation list.
So that is not an affidavit.
You
You can put
somewhere.
it on affidavit.
But in our main read petition, because when the gradation list was prepared in 2021 after the cutoff date, on the basis of this exemption provision, impugned provision, all the promotions have already been made. 2021, 2023. After even the judgment came into with effect from the at the ends of the Supreme Court by laying down the principles of law, they are also still taking the same steps.
Then all the new facts have to be
No,
brought
no,
to
these
record.
are
Because the
colored. Here the
judgment was
dispute is
delivered on
whether
1st of
exemption provision is
September
ultra virus or not.
2025.
Your Lordship laid down the law. Whether the exemption provision under 11, Rule 11 and Rule 15 as framed in exercise of power under Article 309, whether to sustain or not, that is to be first decided. And if that will be decided, goes yes, if these are ultra virus, then the question will come whether the persons, those who are even got the promotions, adheres that provisions of law, they will come back to the earlier position and the gradation list is to be reshuffled or not. Now what they are doing, awaiting the pending cases, result of the pending cases, they are now proceeding in the same footing. My resolute submission before Lordship is, here first of all, the provisions which we have asserted with a prayer, let these exemption provision be declared as ultra virus. Let it be dealt with first. Then next is the courts, they already Supreme Court has laid down the law. Then another judgment, also Your Lordship, Honorable Justice Aniruddha Bose has delivered a judgment that in the judgment bonds I have given. That is, Your Lordship will find, that's the interesting point. Here, the elementary cadre teachers constitute two level. Paragraph 29 of that Devesh Sharma judgment. That one is constitute from class 1 to 5, which are child-centering, psychology-oriented teachers is required to be appointed. Their pedagogical training and city training covers this. And the teachers, those who are engaged for class 6 to 8 with the higher qualification, with PhD qualification, they are subject concerned teachers. What happened in 2018, NCT being the competent authority, brought in a notification that graduate teachers can be also appointed in primary levels. That means class 1 to 5 levels. That was debated in different high courts. That was ended by it has also concerned. Here what has happened, the level 5 people.
You are arguing in vacuum. There are please, with all humility in my command, the things are very clear. A statute has come which creates an embargo that nobody can be appointed as a teacher unless he has a TET qualification. There is a subordinate legislation or a delegated legislation, whatever be the category. If it runs counter to the spirit of the parent act, it is always regarded as an ultra virus. There cannot be any two questions. The question either what I think is making an answer, which is a more larger issue. That once the Supreme Court has said that yes, there is a condition which is put into the RTE Act, which requires the compulsory training of the TET certificate. Now there are many teachers who have been appointed prior to their due. What to do? Just to give an equitable consideration into this aspect, the court has said that you qualify within 2 years from the date prospective judgment. That date has not expired. You say that a review was filed at the behest of several the government. In that, the court has further extended a period of 1 year. So now it becomes a 3 years in 2028. Now, what is a declaration will do? If a declaration has to be done in this regard, can they undermine the judgment? The judgment is based on RTE Act. Can they do it? If they have done it, will it not a contentious act? If it is a contentious act, who is the competent court to take up the contempt? Tell me. You are arguing so vociferously. I was just thinking aloud. Now the question is, suppose in the meantime, the 3 years period is there, which will expire in the month of September 2028, sir. Still there are 2 years left. Anybody who will qualify, I'm thinking in a more wider manner. any person who qualifies TET, in between that, you are promoted today. What would be his position? Below you or above you? Has it been answered here? Not. If a time for qualification has already been given, their length of service is more than you. How they will put? Where they will be put?
That is required to be answered, Malad.
That is what I'm saying. You are not arguing on that. You are arguing on a ultra-virus thinking. I'm thinking more aloud that what would be the position.
Malad, I am just the other party.
Can it not? There are two things. Either to hold the promotion, which is against the spirit, it will demoralize many officers or teachers who are already there, or to adopt a particular mechanism by giving some kind of a leverage to it, that in the event if they qualify, their position would be in such situation. These other things have to be pondered upon, and therefore their presence is also necessary.
Their presence, Malad, I agree, their presence is necessary.
You are arguing really on a vacuum. There cannot be any dispute if the Parent Act comes, and if the subordinate legislature runs counter to a Parent Act or offends the object of it. Who says that it will not be declared as a draft?
Malad, the petitioners
not unnecessary.
Malad,
Thinking that what to do, what will it?
Malad, my respect to Commission with RCB.
25 years or 30 years ago, when RTB did not come. So it still has a long tenure. On the date of joining. Then on the date of now he has joined after RTE with TET.
With qualification.
With TET. Now, what's happened? If he qualifies TET, now it's 27.
Malad, they have
given a promotion.
Malad, may I just
He will be falling in queue. Only because of this qualification. The Supreme Court has not said that your seniority will go or seniority will be
Malad, my respect to submission before Lordship is, they got promotion while we are alive and we are eligible to get promotion. And by superseding us on the strength of this ultra-virus provision, they got promotion.
The difficulty
now they are now going again
promotion. I'm putting a question. Difficulty will again. If the promotional post is 10, if 10 persons above you who has born in the cadre before you,
they are not in the cadre. That's the question, Malad. That's the question, Malad. That I want to answer.
He has joined. He has joined.
They were not in the cadre, Malad. That is interesting. Your Lordship kindly appreciate those who are appointed
you are trying to.
No, Malad. That we have stand. We have specific stand. We have taken.
You resurrect the Tedun.
No, Malad. We have taken the specific stand.
Only question is, suppose if their entry in the school is prior to RTE Act, Supreme Court has recognized.
But the
Supreme Court has also recognized that if their tenure is more and only the retirement age is left below 5 years, their protection has been given.
Yes, I am not, Malad.
So they are born in the cadre. Yes. Prior to RTE Act, much before your...
No, that is, if had it been so, then matter would have stood in different footing. But all those teachers are Shiksha Swakshasevi Shiksha Sahayak. But they were regularized as Jilla Parishad teacher. They were brought over to the cadre after our recruitment. But you Lordship kindly appreciate that we have given the amendment. 2014, they became the member without TET qualification.
Have you challenged us that they cannot be brought from a Shiksha Sahayak to a Jilla Parishad teacher? Have you challenged their notification? Have you further challenged that from Jilla Parishad teachers, they cannot be brought as a regular teacher in the government school? You have not.
Then accepting that, Madam, may kindly appreciate, accepting that they are a member from 2014, not prior to that. And prior to that, we are They were brought over to the Malad cadre. By that time, they were not in position of the TT Malad.
You did not.
And even you see today, they are not in position of the TT. Then next question will arise, even a person.
I believe I have not been able to tell you what is passing in my mind, or it's my misfortune that I am unable to expressly indicate what is passing in my mind. My incapacity. I'm not saying I'm incapable. I could not convey what is passing in my mind. That's a default on my part.
We
We
all
consider two aspects of the matter, sir. You are taking, if they are Shiksha Sahaya, they are not governed by the RTE. Are they?
They will be governed, Malad. Answer is yes.
Differently?
Malad?
Differently? Tell me.
Not
Differently?
Not differently, Malad.
Not different. Under what cadre they would remain?
They will.
The Shiksha Sahaya cadre is a different category of the person.
Can they remain, Malad, in the 3 levels of promotion, higher level, when we are available? Can they, without TT,
Sir,
they will continue at the post of top level?
If they are a different category, then there will be a different hierarchy.
Yes, that is one of the rule.
Different hierarchy.
Yes, Malad.
How you are concerned with their hierarchy.
I am just coming, Malad. That is why I am coming to the point.
State away appointed after RTE Act, then you are a separate homogeneous class. Are you not? If you are a separate homogeneous class, then travel within your class. Do not transgress the class of another.
We are not going to their class, Malad.
What you are,
they are entering to our class. That is why we are trying.
You are
constant to approach this court, Malad.
You are trying to.
Malad, they are coming over to our cadre.
Coming into a one homogeneous class. Anyhow, that is what is there. If they are a teacher for per se, if the right to TET has been preserved, they can have the TET within 2028 by 31st of August. If they acquire the TET by 31st of August 2028, what would be their right is the main concern to us.
Yes, Malad. That is also concerns for us, Malad. That is also concern for us. If they will be put to in the cadre, then from which date they will be put to in the cadre?
That is what a larger.
That is why we have prayed for, let the provisions under basing upon which they are getting promotions. Now they are going to again get the promotions. Let that provisions
give a notice to them. Could not be argued in media or in a vacuum. We will consider it.
Then, Malad, till date, at least state government may not move the hours.
We will not.
Without any specific proper application, the evasive statement that we have.
Application, we will consider. We are on an apprehension of presupposition. We are not going
Well, I was only saying